हेलो हेलो हेलो। हेलो कंट्रोल सुरेश।
संदीप
हेलो 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 चेक। हेलो ठीक है।
कुछ ऑफ नहीं जा रहा है।
That section 6 is there. No, let's go. It will continue for they already Lord, may I?
We will commence from petition side.
There are 4 petitions where I find Union of India is a party in the cost list, but I would rather prefer to say that I'm addressing the court as Attorney General rather than appealing for any particular party, even though I may have some shades of views which may try to support a point of view which petitioners have presented. So these are 5 cases where I find Union as a party. In the cost list, there's 18, 27, 33, 35, and 36.
Lord, may I seek your lordship's permission just to say 2 words with the kind, the learned attorney would permit me. There was one aspect which may not have engaged your lordship's attention, that though the code had been brought into force on 21st November 2025, the 2 laws were running in tandem and parallel. But on 2nd February 2026, a notification came to be issued formally repealing the Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. My lords may not, I'm not sure whether...
These are not formally on record.
So there's a formal repeal. So now we are considering...
20 Act, 104 section of 2020, the new act, said these acts shall be repealed.
Yes.
Shall be repealed by issuing separate notification.
Yes, but that had somehow escaped their attention. So 2 notifications were issued on 21st November and 8th December, but both of them, they had not executed the formal repeal. That comes on 2nd February. So today, my lord, the situation is that now the
Industrial Dispute Act is
now section completely repealed, and now there's a section 6 of the General Clauses Act and 104 of that governs the thing. So we are really only on the pipeline matters now, which might be in the pipeline under a repeal statute.
pipeline or pending before different forms as you.
In that sense, pipeline, which are pending before your lordships or pending in some high court. But the definition which we are considering here no longer exists.
Exactly.
And the new definition now has formally taken over. It's not running in tandem or parallel anymore. If I can just place those notifications, if it is of assistance to your
This
lordship.
was keeping in mind this aspect, the subsequent events and the new legislation. That's why on 16th February 26, the day when we kept it for directions, and in para 4 and 5.
I saw that, Lord. I saw that.
Pipeline was also keeping this mind that the issue is now stand quite shortened. It's only for the, as you rightly say, for the transitional matters which originated at the time when the old act was there, until it has been first substituted by in 2020 by the new act and now formally repealed.
Now formally repealed. So only that formal repeal was perhaps not drawn to your lordship's attention on 16th February. And there's also an amendment act of 16th February. In the code has been amended formally by Parliament to encapsulate that repeal.
Yeah. You can ask your junior to.
We have
just
just
give all
made a
the
compilation of the 3 notifications.
Yes.
Just for your lordship, the 3 notifications of 21st November, 8th December, and 2nd February are all 3 there. Just for.
Well, Lord, there is, with your permission, there is one more issue I'd like to flag before the formal hearing begins. My Lord, I would like to alert this court to the possibility that any judgment rendered by this court on the interpretation of the old law will have an impact on the new law. And this, my Lord, may not be fair to us on this side, because now the 2 sides are pretty clear, my Lord. There is one side asking for the reconsideration of Bangalore water supply, and there is this side saying it need not be reconsidered. Now, my Lord, my question for consideration is this. Whatever view your lordship takes of the matter will definitely have an impact on the new law, the definition of industry under the new law, my Lord. And we are not here called upon to address you on the question of the new law. Therefore, my Lord, this danger has to be averted. How do we avert this danger, my Lord, without transgressing into the constitutional validity of the new law, which, my Lord, we want to keep it as an issue which will be raised in times to come. As of today, my Lord, there is no petition pending before you.
That much clarification can be given, that while taking a view with respect to whether the Bangalore water supply or with respect to the original definition
Yes.
under the repealed act, while construing or interpreting that part,
Yes,
I think that if the word of caution can always be put that this interpretation only relates to the law as it used to be at that time.
my lord, yes, but with respect, my lord, there is an unavoidable overlap. For the reason,
That
my lord,
always
I wish to
happens
make
that-
it clear, my lord, so that my rights are protected, that's all. The point is, there is an unavoidable overlap between what your lordships may decide and what the new law says. But what the new law does is, it basically, my lord, the crux of the matter today, as far as I see it, is the request on the other side to remove charities and from the
So we are
purview.
not hearing that matter for the time being because
But because below the new law removes it. Now, the point is we are going to challenge that removal of charities from the new law and also very wide definition of social work.
any
All social work is excluded from the new law.
that challenge we will independently deal with.
It is true, my lord, but your lordship's judgment will
Just to put it in a different,
bind us as far as any challenge to the new law is concerned, my lord. Therefore, I wish to make it clear. All submissions are completely without prejudice to our contention.
Yes,
The
yes.
new law is liable to challenge.
Yes, that of course we
That you
clarify.
should may keep in mind because
just put it on a different,
submission will be without prejudice.
put it on a slightly different track, taking cue from Ellen's submission. Imagine there is benches today assembled to look into a challenge to a new law. Imagine. And then the court will find out whether after a repeal of earlier law and a judgment which prevailed with an earlier law, will it cast a shadow on the new law at all? The court will see it from an entirely different angle.
True.
Entirely different angle. Therefore, whether without a challenge to the new law, as today court is not confronted with
No, I
that.
just want to clarify one thing. There is a challenge to the new law.
Not before this bench.
Can I just complete? It's writ petition 26330.
Mr. Gopal, if there is, we will separately
No,
examine
I'm
that.
just saying we need to
Not
bear in
challenge.
mind that Parliament has taken a call on the
We
definition
hope
and
that
exists.
we bear in mind and that much
Yes.
basic understanding we possess.
No, no.
Now let's
No,
start.
I'm just
If
clarifying
valid
that
has started already, I have fixed the
I'm
time,
saying
I will
that-
not allow anything
that
to
writ
go beyond that.
writ is pending.
start,
The Lordship
please.
may consider it at some point.
Yes, Mr. Dhandu.
Yeah, Your Lordship. And it's, personally speaking, it's, I have a lot of reflections and remembrances to how, what might have gone into the mind of the learned judge who authored his opinion. And in a manner of speaking, it's a kind of a Kurukshetra here. Now, there are only Pandavas on either side. There are no Kauravas and Pandavas. Because both are articulating some various issues on some very common concern. But why is that the court is now called upon?
Yes, please.
Why the court is now called upon to answer this question at all? But an easy answer would have been that the new law has come, it has taken over the field, and whenever there is an application, a new law, and whatever the precedents occupy the field under the old law, otherwise repealed or amended or whatever it is, they may be cited in support or cited in opposition under the formulations of the new law. But then we're not arguing in the abstract, because what happened is the new code, the 2020 code, as to a considerable extent, picked up from paragraphs 140 and 141 of the Bangalore water supply. The new definition has picked up something from the judgment. But then the trouble or the question still remains as to number of illustrations which the Bangalore water supply looked into, various activities the Bangalore water supply looked into, and answered either way, they may continue to arise, time and again in future, particularly in instances like charitable institutions, philanthropic institutions, education, or by and large, governmental functions. So therefore, when Bangalore water supply was heard, and then if a lot will see Bangalore water supply, right from Banerjee onwards, goes by and large to a large extent on Australian precedents. And because Industrial Disputes Act was also borrowed to a considerable extent on the Australian law. So more than 1904, 1910 Australian experience. And that's how Banerjee onwards, there was a long discussion on why a large, wider import of the words used in the industrial definition of industry came to be considered. So today, if the court were to say, in terms of the issues framed, can I take your lordship to the courts has framed the issues for consideration in the order dated 16th of February. We have our compilations in volume 1 of my volume 5B. Volume 5B of the compilation. We have made available hot copies also for the court.
4B and 5B for the purpose of 4B and 5B.
I'll be referring to volumes 4B and 5B, which are compilations filed on behalf of the Attorney General. And my written submissions in volume 1A.
1A. Yes, please.
Your Lordship, at page 139 is the order where your Lordship framed issues. Let me read them and then place my humble observations on how do you go about with answering these issues. Issue number 1, I find issue number 1 has 2 parts. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by Honorable Mr. Justice V.R. Krishna and so and so, to determine if an undertaking or enterprise 139. Volume 5B.
Rani, these are only the judgments which are being relied upon. 139.
At page 139, this compilation has an entire set of judgments, including Bangalore water supply, and then earlier.
All 37 judgments are.
That's right. But I'm reading at page 139.
The order dated 16th February.
16th February 2020, by which your lordships framed the issues for consideration by this 9. We don't have hard copy. Let them.
Page 139.
issue, page 139, issue number 1. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by Honorable Mr. Justice Krishna Iyer in Bangalore Water Supply to determine if an undertaking or enterprise falls within the definition of industry and lays down the correct law. I pause here for a minute. The issue, I think, is advisedly framed like this to only go into the question whether an undertaking or an enterprise falls within the definition of industry and lays down the correct law. Now, and whether, second part of it, and whether the Industrial Disputes Amendment Act 1982, which seemingly did not come into force, and the Industrial Relations Code 2020, section so and so, have any legal impact on the interpretation of the expression industry as contained in the Municipal Act. So if I consider these as two issues, two separate issues, and because they may have those significance, so let me, then the second issue, whether social welfare activities and schemes or other enterprises undertaken by the government departments or their instrumentalities can be construed to be industrial activities. The issue also again advisedly uses the word enterprises. Then for the purpose of section 2J of the ID Act. Now, 3, what state activities will be covered by the expression sovereign function and whether such activities will still fall outside the purview of section 2J of the ID Act, any other issue that may arise. Now, I think it's important for us then to go back in point of time to the referral order. The earlier order, referral order, as we call it, which is in the same volume at page 94,
90.
which is a reported judgment, 2005, 5 SEC 1.
Yes, we have got 90.
Yes, the judgment begins at page 102.
Jabir Singh matter.
That's right. Let us look at a couple of paragraphs which probably persuaded this court to enter into a question of a reference, para 2, at page 102, on the question whether Social Forestry Department of State, which is a welfare scheme, undertaken for improvement to the environment would be covered by the definition of industry under section so-and-so. The aforesaid benches, which are noticed in paragraph 1, of this court culled out differently the ratio of the 7-judge bench decision of this court in the case of so-and-so. And both of the 3 judges in the case of Chief Conservator of Forests in Kondera and based on the decision of Bangalore water case came to the conclusion that the Social Forestry Department is covered by the definition of industry, whereas the 2-judge bench decision in so-and-so took a different view. And the cleavage of opinion between the 2 benches of the court seems to have been at the basis of the 7th bench decision of the court in so-and-so. The present case, along with the other connected cases, the correct decision in the case that was doubted has been placed before the bench. Various decisions rendered by the court prior to and after the decision in Bangalore water on the interpretation of the definition of word industry and industrial disputes act have been cited before us. It's been strenuously urged on behalf of the employers on the expansive meaning given to the word industry with certain specified exceptions carved out in judgment Bangalore water is not warranted by the language used in the definition clause. It's urged the government and the department, while exercising its sovereign function, have been excluded from the definition of industry. On the question of what is sovereign function, there is no unanimity in the different opinions expressed by judges in Bangalore water case. It is submitted that in a constitutional democracy, the sovereignty vests in the people all welfare activities undertaken by the state in the discharge of its obligations and the directive in state policy contained in Part 4 of sovereign function to restrict the meaning of sovereign function to only specific categories of so-called inalienable functions like law and order, legislation, judiciary, administration, the like is uncalled for, submitted that the definition of industry given in the Act is no doubt wide, but not so wide as to hold to include all kinds of systematic organized activities undertaken by the state and even individuals engaged in the professional philanthropic activities. Then, on behalf of these, I'll skip paragraph On behalf of the employers, it also pointed out that there is no unanimity in the opinions expressed by the 9 judges in Bangalore water case on the ambit of definition of industry given in the Act. Pursuant to the observations, the legislature responded and amended the Act by the Industrial Resource Amendment Act 1982. In the amended definition, certain specified types of activities have been taken out of the purview. The word industry, the Act stands amended, but the amended provision redefining the word industry has not brought into force because notification to bring this provision, the effect has not been issued in accordance with subsection 2. Section 1, the amended Act, the amended definition thus remains the statute unenforced a period now more than 23 years. Now kindly switch over to the long discussion, Bangalore water supply. Page 110, paragraph 18. There is some point of view that there is a difference of opinion among the judges, but I think it's in a very narrow area. And paragraph 18, Krishnaya himself who delivered the main judgment in Bangalore water at various places in his opinion expressed that the attempt made by the court to impart a definite meaning to the words in the word definition history is only a workable solution until a more precise definition is provided by the legislature. See the following observation. Our judgment here has no pontifical flavor, but seeks to serve the future, however, till changes in the law or industrial culture occur. That's important words. Law, especially industrial law, which regulate the rights and remedies of the working class, unfamiliar with the sophistications of definitions and shower of decisions, unable to secure expert legal opinion what poverty pricing or the justice market, and denying them the staying power to withstand the multi-docket litigation de facto denies social justice. If legal drafting is vagaries and definitions indefinite and court rulings contradictory. Is it possible that the legislative chambers are too preoccupied other pressing business to listen to court signals calling for clarification of ambiguous clauses? A careful prompt amendment of section 2J would have preempted the docket explosion before tribunal and court. I pause here and then kindly come to paragraph 19. Again, paragraph 145, the court echoes the same. I'm going to read it once again when in the course of my submission. 145 is extracted in paragraph 19. I read paragraph 145. We conclude with a diffidence because Parliament, which has a commitment to the political nation to legislate promptly in vital areas like industry and trade and articulate the welfare expectation in the constraints portion of the Constitution, has hardly intervened to restructure the rather clumsy, vaporous, and tall and dwarf definition or tidy up the scheme. Therefore, the court, does Krishna himself think the definition of industry were clumsy, vaporous, and tiny and all that? I'll come back later about that. Then come to a paragraph in the next page, paragraph 21. Just keep it here. The dissenting opinion of Justice Jaswant Singh for himself and Tuldapur Kajay concludes with the following observation. In view of the difficulty experienced by all of us in defining the true denotation of the term industry and divergence of opinion in regard to that too, as has been the case with this bench also, we think it is high time the legislature steps in with a comprehensive bill to clear up the fog and remove the doubts and set at rest once for all the controversy which crops up from time to time in relation to the meaning of the aforesaid term, rendering it necessary for larger benches of this court to be constituted, which are driven to the necessity of evolving a working formula to cover particular cases. By the time we did not have the 2020 court, we are still awaiting Parliament. Court thought Parliament is still yet to act. So the above observations contain the dissenting view of Justice Jaswant Singh have proved prophetic. The legislature has intervened and amended the definition of industry in 1982, but for more than 23 years, the amended provision has not been brought into force. The unamended definition with the same vagueness and lack of precision continues to confuse the courts and the parties. I may not agree with that observation, but I'll come to it later. The inaction of the legislative and executive branches has made it necessary for the judiciary to reconsider the subject over and over again in the light of the experience of the working of the provision on the basis of the interpretation judgment in Bangalore water rendered as far back as the year 1978. The next paragraph. In the case of Coibot, a two-judge bench, the court speaking to Sujata Manohar J, surveyed all previous decisions of the court, including the seven-judge decision in Bangalore Water, and passed an order of referral to the Chief Justice constituting a larger bench or more than seven judges if necessary, the following part of the order. Since the difficulty is the reason because of the judicial interpretation given to the definition of industry in the Industrial Disputes Act, there is no reason why the matter should not be judicially re-examined. In the present case, the function of the coir board is to promote coir industry, open markets for it, and to provide facilities to make the coir industry's products more marketable. That's in the nature of a service. It's not set up to run any industry itself. Looking to the predominant purpose for which it is set up, we would not call it an industry. However, if one were to apply the test laid on Bangalore Water Supply, it is an organization where there are employers and employees. The organization does some useful work for the benefit of others. Therefore, it will have to be called an industry under the Industrial Disputes Act. We do not think that such sweeping tests as contemplated the Industrial Disputes Act, nor do we think that every organization which does useful service and employs people can be labeled as industry. We therefore direct the matter to be placed before the Honorable Chief Justice to consider larger bench should be constituted so and so. In the next paragraph, when a matter was listed before a bench, three-judge bench, the request for constituting a larger bench for consideration of the judgment so and so was refused both on the ground that the Industrial Disputes Act has undergone an amendment and that the matter does not deserve to be referred to a larger bench as the decision of seven judges bench is binding on the benches of this court or less than seven judges. The order refusing reference to the seven-judge decision by so and so reads thus. We have considered the order made in civil appeal so and so, delivered almost 2 decades ago. The law has since been amended pursuant to judgment, though the date of enforcement has not been notified. The judgment delivered by so and so does not, in our opinion, require any reconsideration or reference being made by a two-judge bench of this court is bound by judgment larger bench. The appeal therefore be listed before the appropriate bench for the election. Thus, the reference sought by two judges to a larger bench of more than seven judges was declined by three-judge bench. As has been held by this court subsequently, in the case of Central Board of Dawudi Bora, the so-and-so, it is open to the Chief Justice and the reference made by the two honorable judges to constitute a bench of more than seven judges for reconsideration of the decision in Bangalore Water Supply. 24, next page. In any case, no such inhibition limits the power of the bench of five judges which has been constituted on a reference made due to apparent conflict between judgments of two benches of this court. As has been stated by us above, the decision in Bangalore Water is not an unanimous decision. Of the five judges who constituted the majority, three have given a common opinion, but the two others have given separate opinions projecting a view partly different from the views expressed in the opinion of the other three judges. Beck CJ, having retired, had no opportunity to see the opinion delivered by the other two judges subsequent to retirement. Krishna J and the two judges who spoke to him did not have the benefit of dissenting opinion of the two other judges, and the separate partly dissenting opinion of Chandrachud Dey, as those opinions were prepared and delivered subsequent delivery of the judgment in Bangalore Water case. Probably that seems to the dynamics of this court with its combination of benches of more than two. In such a situation, it's difficult to ascertain whether the opinion of Krishna J given on behalf of Bhagavati and Desai J can be held to be an authoritative precedent, which would require no reconsideration, even though judges themselves expressed the view that the exercise of interpretation done by each one of them was tentative and is only a temporary exercise till the legislature stepped in. Legislature subsequently amended the definition, but due to lack of will both on the part of the legislature and the executive, the amended definition for long period 23 years has remained dormant. Sri so-and-so is appearing for National Remote Sensing Agency, which is an agency constituted by the government in discharge of its sovereign function dealing with defense, research, atomic energy, and space, falling in the excluded category in subclass 6 with the amended definition industry in section 2J, relies on the following decision in support of its submission that where the unamended definition in the Act is ambiguous and has been interpreted by the court not exhaustively but tentatively, until law is amended, the amendment actually brought into the statute can be looked into for consideration, for construction of the unamended provision. Then next paragraph, Andhyajana further argues that the Industrial Disputes Act 1982 noted the views, not only of the definition of industry is provided in various other provisions, the Principal Act also amended. Subsection 2(1) of the Amendment Act say the Act shall come into force in that day so and so by notification the official gazette point. It's submitted either the whole of the act should have been notified for enforcement or not at all. The Amendment Act does not contemplate a situation where the central government notify only some other provisions of the Amendment Act for enforcement and withhold from enforcement other provisions Amendment Act. It's argued that such piecemeal enforcement act is not permissible by subsection 2, so and so, it is Benian. Then little later, and then I skipped that particular paragraph, come to paragraph 28. Senior advocates with O.J. Singh and Colin Gonsalves, counsel appearing for the employees very vehemently oppose a prayer made on behalf of the employers for referring the matter to a larger bench for reconsideration of the decision in Bangalore water case. I think they have the same stand today. It is submitted that even though the definition of the industrial disputes have been amended in 1982, it has not been brought into force for more than 23 years, and the reason disclosed to the court when the enforcement of the Amendment Act was sought in the case of Ultimate Shreen in its sound justification, the stand of the UN of India was for the category of industries. Excluded the amended definition, no alternative industrial dispute resolution forums could be created. For the opposite reason, the central government did not enforce the provision of the Amendment Act, which provided a new and restrictive definition of industry. Then the council with the employees relied on AKRI in support of submission that is not open to the court to issue the amendments to the government to bring into force the provisions of the Act. Submitted that it's the prerogative of the government in accordance with the provisions of the Amendment Act to enforce the provisions of the Act when it finds that there are conditions suitable to take out the purview of the definition of industry, certain categories of industries in which the employees have been provided separate forums for the redressal of the industrial disputes. Then paragraph 30, on behalf of the employees submitted pursuant to the decision, although the legislature responded by amending the definition of industry to exclude certain specified categories of industries from the purview of the Act, employees of the excluded categories of industries could not be provided alternative forums for redressal of the grievance. The unamended definition of industry as interpreted in Bangalore water has been the settled law of the land in the industrial field. The settled legal position has operated well, and no better enunciation and scope and effect of the definition could be made either by the legislature or by the Indian Labour Organization in its report. That's a very ambitious statement. Then kindly come to the court looks at paragraph 35 at page 117.
33 also.
Where fireboard is referred to, and for good reason they're referring to paragraph 19. After paragraph 19, which I read out earlier at page 118, this is how the referral order reads. The above quoted observations were criticized on behalf of the employees, stating that for making them, there was no material before the court. We think that observation of the learned judge is not without foundation. The experience of judges in the apex court is not derived from the case in which the observations are made. The experience was from the cases regularly coming from to the court, to the labor court. It is experienced by all dealing in industrial law that overemphasis on the rights of the workers and the undue curtailment, the rights of the employees to organize the business through employment and non-employment has given rise to a large number of industrial and labor claims resulting in awards granting large amounts of back wages for past years, allegedly as legitimate dues that the workers are found to have been so and so. Then after placitum, yes, the awards of reinstatement and the arrears of wages for the past years of labor codes by treating even small undertakings of employers and entrepreneurs of the industry's experience as a serious industrial hazard, particularly by those engaged in private enterprises. They experience that many times idle wages are required to be paid to the worker because the employer has no means to find out whether and where the workman was gainfully employed pending adjudication. The exploitation of workers and the employers has to be equally checked. Law, and particularly industrial law, needs to be interpreted as to ensure that neither the employers nor the employees are in a position to dominate the other. Both should be able to cooperate for their mutual benefit in the growth of industry and thereby serve the public good. An over-expansive interpretation might be deterrent to private enterprise in India where public employment opportunities are scarce. The people should therefore be encouraged towards self-employment, embrace within definition of industry even liberal professional like so-and-so and the like, which are occupations based on talent, skill, and intellectual attainment, is experienced as a hurdle by professional and self-pursuers in carrying on their profession in a city. No doubt, even liberal professions are required to be regulated and reasonable restriction imposed. If you adopt an ideological, philosophical approach, we would be treading on the wrong path against which learned Sri Justice Krishna Iyer himself recorded a caution in his inimitable style thus. Here we have to be cautious not to fall into the trap of definitional expansionism, bordering on reductio ad absurdum, not to truncate the obvious amplitude of the provision to fit into our mental mold of beliefs and prejudices or social philosophy conditioned by class interests. Subjective it shall not be further to the forensic thought, if credibility with a pluralist community is a value to be cherished. Courts do not substitute their social and economic beliefs for the judgment of legislative bodies. I think very often we take a different note on this. Of course, courts do, but then how far they can do is a different question. So a worker-oriented approach in construing the definition of industry, unmindful of the interests of the employer or the owner of the industry and the public who are the ultimate beneficiaries, would be a one-sided approach and not in accordance with the provisions of the Act. We also wish to enter a caveat on confining sovereign function to the traditional so described as inalienable functions comparable to those performed by a monarch, a ruler, or a non-democratic government. The learned judges in Bangalore supply seem to have confined only such sovereign functions outside the purview of industry which can be termed strictly as constitutional functions of the three wings of the state, executive, legislative, and judicial. The concept of sovereignty in a constitutional democracy is different from the traditional concept of sovereignty, which is confined to law and order, defense, lawmaking, justice dispensation. In a democracy governed by the Constitution, the sovereignty of the people and the state is obliged to discharge its constitutional obligation contained in the directive principle of state policy. From that point of view, wherever the government undertakes public welfare activities in discharge of its constitutional obligation, as provided in Part 4 of the Constitution, such activities should be treated as activities in discharge of sovereign functions falling outside the purview of industry. That's what your Lordship is going to look at in the second and the third issue. Whether employees employed in such welfare activities of the government require protection, apart from the constitutional rights conferred on them, may be a subject of separate legislation. Please kindly mark it. May be a separate subject of separate legislation, but for that reason, such governmental activities cannot be brought within the fold of industrial law by giving an undue expansive and wide meaning to the words used in the definition of industry. In response, Parliament intervened and substituted the definition of industry by including with its meaning some activities of the government and excluding some other specified governmental activities and public utility services involving sovereign function. For 23 years, the amended definition has remained unenforced. Government has been experiencing difficulty in bringing into effect the new definition. Issuance of notification has been withheld so far. It is therefore high time for the court to re-examine the judicial interpretation given by it to definition of industry. The legislature should be allowed to greater freedom to come forward with a more comprehensive legislation to meet the demands of employers and employees, the public and private sectors. The inhibition, the difficulties arise being exercised by the legislature and the executive in bringing into force the amended industrial law, more due to judicial interpreted definition of industry need to be removed. The experience of working with the Provisions Act should serve as a guide for a better and more comprehensive law on the subject to be brought into force without limitation. Now that we have reached that stage, 1982, an unnotified law is no longer part of the canvas. So now that we've reached the 2020 code, a couple of questions may arise in your mind as Ms. J. Singh was trying to canvas. Now, what is that important public purpose that will be served by this court looking into the Bangalore water supply in its expansive sweep and say that in one way or the other, to some extent or the other, the Bangalore water supply is not good law. There has to be some impact factor, suppose. Is it because the new code, which is partly lifted from Bangalore water supply in the definition of industry, but partly departing from it? Therefore, if your Lordship say that it's partly good law, certainly is going to carry on and have its cast a shadow on the application interpretation of the new code. But to say on the other hand, no, don't do it at all. The new code will take care of itself. Therefore, there is some problem where the court may have to very carefully tread. So the court were to say, well, it's good law for all practical purposes. And the new code will certainly receive its color from this court's imprimatur of the Bangalore water supply. And to what extent that exercise will be undertaken is also a question for Lordship's consideration. And let me complete this and then come to it. Paragraph 42.
Yes.
I'm leaving for the time being paragraph 41, paragraph 42. In construing the definition and definition clause and determining its ambit, one has not to lose sight of the fact that in activities like hospitals and education, concepts like the right of the workers to go on strike or the employer's right to close down and lay off are not contemplated because their services, in which the motto is service to the community, if the patients or students are to be left at the mercy of the employer and the employees, exercising their rights at will, the very purpose of service activity would be frustrated. That we are respectfully inclined to agree with the observations of Jadendra Gadkar in Harinagar case, as we have repeatedly emphasized. In dealing with industrial matters, industrial adjudication should refrain from enunciating any general principle or adopting any doctrinal considerations. It is desirable that industrial adjudication should deal with problems as and when they arise and confine a decision to the point which strictly arise on the pleading between the parties. That's a very ambitious statement, if I can put it like that, because when you have issues like an industrial definition, to say that can be no room for doctrinal considerations is going to be a problematic statement. But that apart, the court is only bringing an attention to the fact that notwithstanding those doctrinal considerations, can you go beyond them to the extent that's possible? That's what perhaps Gajendra Gadkar is talking about here. We conclude agreeing with the conclusion of honorable judges in Hospital Madhu Sabha. Though Section 2J use words a very wide denotation, a line would have to be drawn in a fair and just manner so as to exclude some calling, services, or undertaking. This court must therefore reconsider where the line should be drawn and what limitations can and should be reasonably implied in interpreting the wide words in Section 2J. That, no doubt, is rather a difficult problem to resolve, more so when both the legislature and the executive are silent and have kept an important amended provision on the law dormant on the statute book. We'll come to it.
The new board. It's a different body.
We've taken the note. My note. Points. Points should be noted.
So the new board will be water supply.
You may read para 45 before concluding this judgment.
Your Lordship, please, sir.
You may just read para 45 also.
Yes, yes. I'll come. We do not consider it necessary to say anything more and leave it to the larger bench to give such meaning and effect to the definition clause in the present context. With the experience of all these years and keeping in view the amended definition of industry kept dormant for long 23 years, pressing demands for the competing sectors of employers and employees, and the helplessness of so and so, the Amendment Act compels us to make this reference. So perhaps that's what persuaded your Lordships to have the second part of issue 1, which says what is the impact of amended 1982 amendment and the current code.
We may add one more angle to this matter. Bangalore water supply is a judgment which came in 1970s. We have the reforms of 1991, which has focused on liberalization, privatization, and globalization. Now, if there is going to be more focus on privatization and liberalization, many of the functions which the state was doing would be performed by the private sector. Then what should be the scope of the definition of industry? Should it still be very expansive, or should it be restricted, or a balance has to be struck? I think that is one of the angles of this case, since that judgment is delivered almost half a century ago.
Correct.
Now we are in 2026, and we have had how many years of liberalization? I say LPG liberalization, privatization, globalization,
Correct.
which is so important for a woman also, LPG.
No, no,
All I will say,
not,
but
not,
so for a
there's no shortage, there's no shortage of LPG.
Can't get it.
There's no LPG shortage today here as far as that is concerned.
small tycoon.
No, but responding to your lordship's observation, let me place the,
Half a century ago, we were on socialist philosophy, and you know what has happened in the property owners case,
That's right.
Ranganatha Reddy, etc.
it's a very important observation.
Yes.
Let me respond to it quickly before I go into the larger question. Now, whatever socio-economic changes happen in a community or a country, particularly where you're talking about liberalization, etc., globalization, privatization, opening up market in a big way, the question will still remain if the definition of industry in 2J had continued to occupy the statute. Then, of course, we need to call in the context of a definition which remains unchanged, whether Bangalore water supply would continue to provide us enough guidance, or we need to go a little away from that or move away farther from that. But today, since we don't have that situation at all, we have both a 1982 interlude, not notified, and a later code which is now occupying the field. Therefore, I think Lordships will have to probably answer these issues in a very narrow perspective as to whether between 1978 to 2020, will it be a good only for the purpose of answering those matters which are pending before the court.
Yes. Matters are
That's
pending
right.
before the
If it's
court.
only for a limited purpose, if it's only for a limited purpose, then of course,
How they can't.
court need not travel a long line of entering into all the debates about what would be sovereign functions, so on and so forth. But if it's for a larger, canvas, then I think I would probably tell the court, be slow in looking into this issue, because the new code, to a considerable extent, has borrowed from para 140 of the Bangalore water supply, but has departed in certain respects. For whatever the court may say today, whether Bangalore water supply in its entirety or partly or rule partly approved or whatever it is, will certainly cast a shadow on the interpretation of the new code, to the extent it has some overlapping. Therefore, I thought it was only for the purpose of answering and responding to the matters pending prior to 2020. Perhaps we walk on a very narrow path. We walk on a very narrow path. Many larger considerations need not enter the mind of the court in unraveling Bangalore is a good law, a bad law, doctrine, no doctrine, etc. So I thought that's something I'm not very clear whether.
It should be activity based.
Yes.
For example, social forestry. Activity based has to be considered.
May I presently place therefore how, for instance, from 2J in the 1947 Act, 1982 definition, and then the current definition. I'll quickly place that so that we have a perspective on where we should probably stop and where perhaps the logos will not go further. Now, kindly take in the compilation.
Just one question.
I'm sorry.
This is referred to para 45.
Yes.
Now, where do we find in the judgment what the pressing demands of the competing sectors were, and what difficulties were faced by the legislature and the executive to enforce the amended definition of industry, which compelled the 5-judge bench to make the reference? Where is that discussion?
No, they go through. There are 3 or 4 cases which have been dealt with. Kindly come back to paragraphs.
No. Paragraph 45 as mentioned refers to, this is the final conclusion, that it is because of the pressing demands and the helplessness of the legislature and executive that we are making a reference.
No, the code goes back to, the code goes back to Bangalore water supply itself to say that Bangalore water supply, both in terms of Justice Krishna's judgment and the opinion by Justice Jaswant Singh and Justice Tulsapurkar, and partly Justice Chief Justice Chandrachud, also take note of it. Now I think that's where, yes.
Please come back to 45.
Yes.
It refers to an incident which was not there when Bangalore water supply was decided. They say that the legislature and the executive are helpless in bringing into force the Amendment Act. That is 1982.
Yes.
That was not there in Bangalore water supply. It precedes 1982 amendment. What prevented the legislature and the executive to enforce the Amendment Act, which is compelling the 5 judges bench to refer it to the Chief Justice. Where do we find that?
No, there is no.
It's not there?
No, there is no material available in the
In
judgment.
the judgment.
But then,
If it is
but
not
then
there,
are you
Mr. Attorney,
placed on record?
what is, we would, at least I would be questioning you.
Yes.
Whether it's a valid reference.
No, but
Whether
I
it's a
don't.
valid reference, first.
Yes,
Secondly, the bench has, in paragraph 24,
yes.
has repeatedly said, this is not an unanimous opinion.
It is.
Madam, just 1 minute.
24, yes.
24, Bangalore water supply, fourth line is not a unanimous decision. Of the 7, 5 were on one side, 2 were on the other side. How is it relevant?
No, I'm not.
7-judge bench, it has to be considered as a 7-judge judgment.
Let,
Srimurthy Fragrances quite recently says,
yes.
irrespective of the number of judges dissenting, it has to be taken as the judgment.
I'm not here to support that at all.
Not
Now, let's look at it from.
Lead opinion which has to. That is the law.
there is-
There may be.
Yes.
Let me put it.
This is the first thing. The 5-judge bench says that it is not a unanimous, as if this is a ground for making a reference. Secondly, Justice Iyer, on behalf of Bhagwati and Desai JJ, whether it can be held to be an authoritative precedent. A 5-judge bench questioning the 7 judges bench.
Yes.
No, that's why when this difficulty arose.
When referring to
That's why when the difficulty.
Dr. Manohar's judgment, which was placed before a larger bench, the larger bench did not agree with the 2-judge bench and did not refer.
That's when the difficulty arose. Kindly turn to why
Social funds.
They were different to opinion.
at page 113, the court, when the earlier endeavor in choir board did not meet with the approval by a subsequent 3-judges bench, at page 113 bottom, that's how these references ultimately been made. So I do not know. I do not know. I'm Go to come back to page 113.
But apropos
the
what
bottom,
fell from my Lord
and then
Justice
there is
Dutta,
one-
I
one-
can just point out one more,
One minute,
one
let
more
me also-
aspect, my lord.
We will not permit Mr. Ansari.
Let me,
He not the way to, let him complete first of all.
page 113 at the
Not
bottom,
anyone to interrupt.
uh, page 113 bottom, that the reference sought by the two judges to a larger bench was declined by a three-judge bench, as has been held by the court subsequently in the case of Central Board of Dawudis also.
113, where are you?
Is open to the Chief Justice,
Paragraph? 113.
page 113 at the bottom. It at the bottom of that page.
Thus, the reference sought by two judges to a larger bench or more than 7 judges were declined by the 5 judge bench. Rightly so, because that's contrary to rules.
Perhaps this is also
Then
not
as
a
has
correct
been-
statement, Mr. Attorney.
One minute, let me,
Judges can refer it to three
One
to
minute.
5, 5 to 7,
That's
and
right.
this is the course that has been followed.
let me complete let me complete
Not
the
that
history.
You can directly refer it to
Let
7.
me complete the history, that's right. I'm not yet completed the history. So that's how I think it came before a bench of 5 judges. Now kindly turn to page 1, 2, 3.
This last line is absolutely correct statement of law, because under the Supreme Court rule, Chief Justice.
The
shall-
Chief Justice takes a call on that, and the 5 judges bench is constituted. The 5 judges bench take a view that there is a need for a reference, and then the matter goes before a bench of 7 judges at page 123, and we have the order at page 125. So in a manner of speaking, when the 7 judges bench places its stamp of approval on the reference, that's how, now it's before your lordship, page 125. Your learned counsel for the parties at considerable length, been taken through so-and-so, and the reference order passed by a 5 judges bench of the court pursuant to which these matters have been placed before us, having given our anxious consideration to the contentions urged of the bar, and the serious and wide-ranging implications of the issue that fall for determination, as also the fact that serious doubts have been expressed in the reference order about the correctness of the view taken in so-and-so, we are of the opinion that these appeals need to be placed before a bench comprising 9 judges to be constituted by the Chief Justice. We order accordingly papers to be so-and-so. Therefore, a 7 versus 7. Bangalore 7, this 7. Therefore, I don't know whether that part of a referral process need to halt your lordship on the further inquiry. And now that we have traveled this distance, the only importance would be, as I said to point out earlier, is that what is the area to be covered by this referral?
So we can examine all issues, but learned attorney, you proceed on the premise that there is a reference to 9 judge bench.
Yes,
And we have to examine Bangalore bars.
that's right.
Page 4 of this information. Just. Page 4.
They say the reference also.
Good point.
May then take your lordships to Bangalore water supply itself directly.
This is volume.
Volume,
Volume 1, it's volume 1. 8, volume 8, is it?
1A.
1A. This one. We have set out the issues which Bangalore water supply is self-framed in paragraph 23 of its opinion.
What is that? This submission.
Page 29.
Is,
Page 29. This is paragraph 23 of Bangalore water supply, which is at page 25 of volume 5B. I thought for the
paragraph
convenience sake.
37, paragraph 37 are you referring to?
Yes.
That's right, 37.
Of Bangalore water supply.
No, he said paragraph 37 of volume 1A.
My written submissions, no.
The attorney's written submission.
Reproduce.
Your lordships also may alongside keep the judgment compilation with this volume 5B, but I'll be probably reading between my submissions and Bangalore water supply concurrently. That para 23 is at page 25 of the judgment compilation, which is volume 5B.
Yes.
I have extracted here only for convenience. That's right.
We are now.
If your lordships also, I said, keep open page 25 of volume 5E for a minute before I read these issues. Because almost every page of Bangalore water supply has some beautiful literature and something which goes far into our visionary thinking as well as the problem which the court encountered.
Has to be read along with the dictionary. Justice.
I mean, we cannot close our eyes and mind to the masterpiece of literature available in judgments, and they are so instructive and also guide us in ways of thinking in unknown and novel ways. I want to read paragraph 22 at page 25 before I take out of the issues. Page 22 of volume 5B. A counter critic, on the other hand, may acidly contend. Will Lords have that page?
Yes, please proceed.
Yes. May acidly contend that if judicial interpretation uninformed by life's realities were to go wild, every home will not be a quiet castle, but a tumultuous industry. Every research unit will grind to a halt. Every god will face new demand, and every service club will be the venue of rumble.
You're reading where?
I'm reading page 25 in volume 5B. I want to keep both of them together. Paragraph 22
20,
at the top of that page.
23 is reproduced in the submission.
That's right. But I just want to
Before
read
that,
para
you wanted to read para 22.
22.
Yes.
So, yes, a counter critic.
Critic may, on the other hand, may acidly contend that if judicial interpretation uninformed by life's realities were to go wild, every home will be not a quiet castle, but tumultuous industry. Every research unit will grind to a halt. Every god will face new demands. What do you want? We did Bangalore water supply. Yeah.
23, 29, 31.
And every service club will be the venue of rumble, and every charity choked off by brewing unrest and the salt of the earth as well as the lowliest and the lost will suffer. Counsel for the appellant struck this pessimistic note. Is it not obvious from these rival thought-ways that law is value-loaded and the social philosophy is an inarticulate interpretative tool? This is inescapable in any school of jurisprudence. Probably just Krishna had in his mind Maxim Gorky's The Mother. It talks about how the industrial class, and it's a very pictorial way. Now let me read these issues. Now let us itemize illustratively the posers springing from the competing submission so that contentions may be concretized. 1A, or establishments run without profit motive industries. B, or charitable institutions industries. C, to undertaking governed by a no profit, no loss rule statutorily but otherwise fashioned fall within the definition of section 2J. Do clubs, other organizations like YMCA, whose general emphasis is not on profit making, by fellowship and self-service, fit in the definitional circle? To go to the core of the matter, is it an inalienable ingredient of industry that should be applied with a commercial object? 2A, should cooperation between employer and employee be directed insofar as it relates to the basic service or essential manufacturer, which is the output of the undertaking? Could a lawyer's chamber, a chartered accountant's office, a doctor's clinic, a liberal professions occupation, a calling be designated the industry? Whether a university or a college or a school research institute be called an industry? Is the inclusive part of the definition in section 2J relevant to the determination of an industry? If so, what impact does it make on the categories? Do domestic service drudges who slave without respite become industries by this extended sense? Are governmental functions stricto sensu industrial, and if not, what is the extent of immunity of instrumentalities of government? What rational criteria exists for a cutback on the dynamic potential and semantic sweep of the definition? Implicit in the industrial law of a progressive society geared to a greater industrialization and consequent concern for regulating relations and investigating disputes between employers and employees, the industrial process and relations become more complex and sophisticated, and workmen become more right conscious. As the provision now stands, is it scientific to define industry based on the nature, the dominant nature of the activity, that is on the terms of the work, remuneration, and conditions of service, which bond the two wings together into an employer-employee complex? I think we should read all the three definitions.
Yes.
Vilash, kindly, before I go further on reading Bangalore water supply, kindly pick up volume 4B, where we have a complete compilation of statutes. Volume 4B. It's titled Statutory and Documentary Materials.
This is the amended.
It is amended.
You just read this.
Original, it is amended. I think we should read this also. Then we go to look.
Yes.
Still handing it over. Still handing it over. Ultimately, they don't have it in this paragraph 10 extract the original definition.
You know,
We step into the extracted paragraph 10.
At page 427 of this compilation, volume 4B, we have both the original definition and the amended definition 1982, page 427. Industry means at the top of it. That originally it was 2J. Industry means, we'll also have that page.
It's 424.
427. Volume 4B. Industry means any business, trade. I just, for the sake of argument, I just close my eyes for the other word, undertaking. I continue to read as if the word undertaking is not there for the time being. So industry means any business, trade, manufacture, or calling of employers, and includes any calling, service, employment, handicraft, or industrial occupation, or avocation of workmen. Now, in a large number of cases, what we will find, the word undertaking has come up for consideration, both in the context of municipalities and few other instances, the word undertaking has received a lot of attention. And therefore, whether it's a nociter of sources or an adjustum generis principle, the court has employed either of them and said, I come to an understanding that undertaking must receive a widest import, whether or not there is a profit motive, a commercial element, and so on and so forth. That's why at the bottom of it, Bangalore Water Supply has reached that wide canvas. Now let undertaking remain there as it is. At the same page, the amended act definition is also available. Now this is how it reads. Industry means any systematic activity carried on by cooperation between an employer and his workmen, whether such workmen are employed by such employee directly or by through an agency, including a contractor, for the production, supply, or distribution of goods or services with a view to satisfy human wants or wishes, not being wants and wishes which are merely spiritual or religious in nature, whether or not any capital has been invested for the purpose of carrying on such activity, or such activity is carried on with a motive to make any gain or profit and includes. I skip again for the time being this block label A and B. You also can come to paragraph 140 of Bangalore Water Supply. Just to make a quick note, page 14, paragraph 140 in volume 5B at page 73.
Page 73.
Page 73, page paragraph 140. That is the concluding part where the court endeavors to define industry as defined and explained in Banerjee as a wide import. A, where a systematic activity organized by cooperation between the employer and the employee. The direct and substantial element is chimerical, for the production and the distribution of goods and services calculated to satisfy human wants and wishes, not spiritual religious, but inclusive of material things of services geared, a celestial beings making a large-scale prasada food, prima facie, that's an industry. That's what the 1982 amendment tries to capture. And a little later, absence of profit motive or gainful objective is irrelevant, be the venture in the public, joint, private, other sector. Then true focus is functional, and 3D organization, the trade business, it does not cease to be so and so. I come back to page 427. Then we see once this definition is more or less borrowed from this part of one paragraph 140, then to the extent what the court was anxious to know, whether the law is now to be on the lines we have debated, that answered in 1982 to a considerable extent. But the 82 Act also excludes certain parts of definition of industry. At page 427, after F1, 2, A, B, etc., there's the middle, but does not include. But does not include, one, any agriculture operation, except that agriculture operation is carried on in an integrated manner with any other activity, and such other activity is the predominant one. Then explanation for the purpose of subclause, agriculture operation does not include any activity carried on in a plantation as defined in so-and-so Plantation Labor Act, or two hospitals, the dispensaries, 3, educational, scientific research or training institutions, or 4, institutions owned or managed by organizations only or substantially engaged in any charitable, social or philanthropic service, or khadi or village industries, or any activity of the government. This is important. Any activity of the government relatable to the sovereign functions of the government. It uses the word very carefully. Activities relatable to the sovereign functions of the government, including all the activities carried on by the departments of central government dealing with defense research, atomic energy and space, or any domestic service, or any activity being a profession practiced by an individual or body of individuals, if the number of persons so and so a body of individuals in relation to is less than 10, that takes care of clubs, associations, etc. Any activity carried on by a cooperative society or a club like body of individuals, if the number of persons employed so and so is less than 10. Now kindly turn to in the same volume at page 701. We have the definition in the new code.
Is there a comparative study made between what has been stated in the judgment with the 1982 amendment and between the 1982 amendment and the labor code?
There have been large number of
distinction.
There have been large number of discussions, consultations. There is a,
Comparative study, it would be useful to the court.
I can place it. There is some consultative committee. There is a parliamentary consultative committee.
We have a chart that,
That chart will be useful.
We'll place it.
We'll place the comparative chart.
We'll place all those material. I thought for the time being,
My lunch provided.
You keep it, there is no need.
701.
Yes, Mr. Tony, let's proceed further. 82 definition, we are not sure how much it is going to help you, as my brother has already pointed out.
That's
Will of the legislature
so this part of
became
this,
of the executive.
the first part of it is as it was in the 1982 Act. Sorry. So at page 701, the definition of industry, the first part of it, I may call it, is parliamentary of the 1982 Amendment Act. And that's again para 140 of the Bangalore Water Supply. But then here, after that, but does not include, we also have a non-inclusion, exclusion clauses. But this exclusion clause is not the same as what 82 amendments sought to bring in. This is a little narrow, but I think it's also important to keep it in mind. So it says, but does not include institutions owned or managed or organizations only or substantially engaged in a charitable, social or philanthropic service. And 2, any activity of the appropriate government relatable to the sovereign functions of the appropriate government, including all the activities carried on by the department, central government dealing with defense research, so and so, or any domestic service and any other activity as may be notified by the central government. I think the parliament has gone very advanced to say if from time to time if there is a need to going by these principles and by any other principles which the state may consider important and relevant, may notify it. Otherwise, they may still say it can be an industry, it need not be an industry. Therefore, these clauses, of course, occurs in many legislations, but in the context of a law like this, it has taken the color from the other part of the definition. Therefore, that's the statutory scheme as it exists today. So if keeping this in mind, let me take your lordships to the Bangalore water supply itself. That's volume 5B. The judgment begins from page 4. May invite your lordship's attention to. I come. An introductory paragraph where the court finds page 19 of the judgment, paragraph 4. Though the tailoring of a definition is the sole forensic job in this batch of appeal, dependent on which perhaps a few thousand other cases await decision. The cycloramic semantics of the simple word industry and the judicial gloss on it in a category of cases have led to the avoidable glut of labor litigation, where speedy finality and working criteria are more desirable. And this delay in disposal of thousands of disputes and consequent partial paralysis in the industrial life is partly blamable on the absence of mechanism of communication between the court and the lawmaking chamber. Cycloramic means a 360-degree panoramic view. That's what it means. Kindly turn to paragraph 18. Okay. Fine. Kindly turn to paragraph 13 at page 21.
These three elements of 13, 14, and 15 taken from hospital.
Yes. Look at the definition.
Yeah, look at the definition. Dictionary in hand, decisions in head, and constitution at heart. Leads to some sure characteristics of an industry, narrowing down the twilight zone of a turbid controversy. An industry is continuity, is an organized activity, is a purposeful pursuit, not any isolated adventure, desultory excursion or casual, fleeting engagement motivelessly undertaken. Such is the common feature of a trade, business, calling, manufacture, mechanical, or handicraft-based service, employment, industrial occupation, or a vocation. I find that these propositions have been picked up from Hospital Mazdoor Sabha and then earlier judgment in Nagpur Corporation. I'll come to them a little later. Then paragraph 14. Likewise, an industry cannot exist without a cooperative endeavor between employer and employee. No employer, no industry, no employee, no industry, not as a dogmatic proposition in economics, but as an articulate major premise of the definition and scheme of the Act, and as a necessary postulate of the industrial disputes and statutory resolution thereof. An industry is not a futility, but geared to utilities in which the community is concerned, and in this mutant world where law is now economic utilities, material goods and services, not transcendental files nor intangible achievements, or the functional focus of industry. Therefore, no temporal utilities, no statutory industry is axiomatic. If society in its advance experience subtle realities and assigns values to them, jurisprudence may reach out to search collective good. Today, not tomorrow, is the first charge of pragmatic law. So we're confined to material, not ethereal end products. And these paragraphs 13, 14, and 15 ultimately get coined as a triple test formula in paragraph 140. Let me go to paragraph 18. And before I read paragraph 18, what, of course, obviously prompted the dialogue, the court says, the last few lines in paragraph 17. The betterment of the workman's law, the avoidance of outbreaks, blocking production, and just and speedy settlement of disputes concern the community in trade and business, goods and services are for the community, not for self-concern. Then para 18. The penumbral area arrives as we move into the outer. Other essentials needed to make an organized, systematic activity, oriented and productive collaboration between employer and employee. And industry as defined in section 2J. Here we have to be cautious not to fall into the trap of definitional expansionism, bordering on reductio ad absurdum, not to truncate the obvious amplitude of the provision, to fit into a mental mold of beliefs and prejudices of social philosophy conditioned by class interests. Subjective wish shall not be father to the forensic thought if credibility with pluralist community is a value to be finished. Courts do not substitute their social and economic beliefs for the judgment of legislative bodies. Even so, this legislation has something to do with social justice between the haves and the have-nots. And naive, fugitive, and illogical cutbacks on the import of industry may do injustice to the benignant enactment. Avoiding scilla and charybdis, we proceed to decipher the fuller import of the definition. Your Lordships know scilla and charybdis means between two dangerous things, the devil and the deep sea. So avoiding scilla and charybdis, we proceed to decipher the fuller import of the definition. To sum up, the personality of the whole statute, be it remembered as a welfare basis, it being a beneficial legislation which protects labor, promotes their contentment, regulates situations of crisis and tension in production may be imperiled by untakeable strikes and blackmail lockout. The mechanism of the act is geared to conferment of regulated benefit of the workman and resolution according to a sympathetic rule of law of the conflict's actual potential between management and the workman. His goal is amelioration of the conditions of workers tempered by a practical sense of peaceful coexistence in the benefit of both, not a neutral position, but restraints on laissez-faire and concern for the welfare of the weaker lot. Then a few lines later, this certainly does not mean that we should strain the language of definition to import into it what we regard as desirable in an industrial legislation, for we are not legislating de novo, but construing an existing act. Crusading for a new type of legislation with dynamic ideas and humanistic justice, an industrial harmony cannot be under the umbrella of interpreting an old imperfect enactment. The court thinks that 2J was an imperfect enactment. I only want to keep this in mind when you're going beyond the reach of 2020. The new enactment has come. So imperfect enactment has now been substituted with what Parliament thinks is a possibly reasonably good enactment. Then kindly turn to paragraph 21. A cynical jurist surveying the forensic scene may make unhappy comments. Counsel for the respondent unions sounded that note. A pluralist society with capitalist backbone, notwithstanding the innocuous adjective socialist added to the Republic by the Constitution, regards profit-making as a sacrosanct value. Elitist professionalism and industrialism insensitive to the worker menace and inclined to exclude a sound and fury of the labor unrest from its sanctified pressing by judicially deindustrializing the activities of professional men and interest group to the extent feasible. Governments in a mixed economy share some of the habits of thought of a dominant class and doctrines like sovereign function, which pull out economic enterprises run by them, come in handy. I thought this is a very broad observation made. Now, the latent love for club life and charitable devices and escapist institutions bred by clever capitalism and hierarchy of so and so, I'm not placing so much of emphasis on these aspects because we are more concerned with the larger canvas. Now, the second part of exclusion in the new definition, the same exclusion in the 1982 definition as to those activities relatable to sovereign function will ultimately...
Already referred to by you.
Right. No.
28.
I come. And page 28, I'll read two paragraphs at page 28, para 28 and 29. The second, though trite guidance that we get is that we should not be beguiled.
27 first.
Beguiled by similar words or dissimilar statutes, context, subject matters, or socio-economic situation. I think that's a very ideal call. And the same word may mean one thing in one context and another in different context. There's a reason why decisions on the meaning of particular words or collection of words found in other statutes are scarcely of much value when you have to deal with a specific statute of your own. They may persuade but cannot pressure. But why they say that in the previous page 27, paragraph 27, where the court extracts from Banerjee,
26 is the extract and 27 they explain.
the court begins to deal with Banerjee from para 24 onwards. But let me only quickly take your lordships to two extracts from Banerjee court set out in paragraphs 26 and 27 at page 27. A panoramic view of the statute and its jurisprudential bearings have been projected there and the essentials of an industry decocted. The definitions of employers, Section 2G, industry, industrial dispute, workmen, or a statutory dictionary, not popular parlance. It is plain that merely because the employer is a government department or a local body, and a fortiori, a statutory board, society, or like entity, the enterprise does not cease to be an industry. Likewise, what a common man does not consider industry does not necessarily stand excluded from the statutory concept and vice versa. The latter is deliberately drawn wider and in some respects narrower, as Chandrasekhar Iyer J. has emphatically expressed. Let me read this paragraph. In the ordinary and non-technical sense, according to what is understood by the man in the street, industry or business means an undertaking where capital and labor cooperate with each other for the purpose of producing wealth in the shape of goods, machine tools, and for making profits. The concept of industry in its ordinary sense applies even to agriculture, horticulture, pisciculture, and so on and so forth. It is also clear that every aspect of activity in which the relationship of employer and employee exists or arises does not thereby become an industry as commonly understood. We hardly think that in terms of an industry when we regard, for instance, to the rights and duties of a master and servant, or of a government and its secretariat, or the members of the medical profession working in a hospital. It will be regarded as absurd to think so. At any rate, the layman unacquainted with the advancing legal concepts, what meant by industry would rule out such a connotation as impossible. There is nothing, however, to prevent the statute from giving the word industry and the word industrial dispute a wider and more comprehensive import in order to meet the requirements of rapid industrial progress and to bring about, in the interest of industrial peace and economy, a fair and satisfactory adjustment of relation between employers and workmen in a variety of fields of activity. And it's obvious that the limited concept of what an industry meant in early times was now revealed to play an enormously wider concept, is to make in various and varied forms of industry so that dispute arising in connection with them might be settled quickly, the dislocation, disorganization, so and so. A few lines later, the conflicts between capital and labor have now to be determined more from the standpoint of status than of contract. Without such an approach, the numerous problems that now arise for solution in the shape of industrial disputes cannot be tackled satisfactorily. And this is why every civilized government has thought of the machinery of conciliation officers, boards and tribunals for the effective settlement of disputes. So what was in the antechamber of the mind of the court was rapid industrial progress and all possible emanation that may happen by rapid industrial progress. And therefore, what should we do to address the questions of industrial peace? Now, the dynamics of industrial law, even if incongruous with popular understanding, is the first proposition we derive from Banerjee. Legislation has to keep in pace with the march of times and to provide for new situation. Social evolution, the process of constant growth, and the state cannot afford to stand still without taking adequate measures by means of legislation to solve large and momentous problems that arise in the industrial field from day to day almost. And now let me take your lordships further to paragraph 29, at page 28. Because look at how the pendulum has been swinging between, on the one hand, we knew industrial changes happening across the globe and ways and means of producing goods and making services available are also undergoing change. At the same time, para 29, we'd only add that a developing country is anxious to preserve the smooth flow of goods and services and interdict undue exploitation. And toward these ends, labor legislation enacted must receive liberal construction to fulfill its role. For when you talk about liberal construction, and where will you draw a line? Much later in the course of the judgment, even Justice Krishna says, how do you draw a line? It finds fault with the Hospital Mazdoor Sabha wanting to draw a line and says, how do you draw a line? So the drawing a line can be sometimes chimerical, sometimes it's like chasing a chimera. So I'll read a few more paragraphs of this and then try to place my comments. Paragraph 31. At the end, after I read many paragraphs from Bangalore water supply, they all ultimately towards encapsulating what is found in paragraphs 140, 141, and 143. Para 31. Absence of capital does not negative industry. Nay, even charitable services do not necessarily cease to be industries definitionally, although popularly charity is not an industry. Interestingly, the learned judge dealt with a point. After enumerating typical municipal activities, he concluded, some of these functions may appertain to and partake of the nature of an industry, while others may not. For instance, there is a necessary element of distinction between the supply of power and light to the inhabitants of a municipality and the running of a charitable hospitals and dispensaries for the aid of the poor. In ordinary parlance, the former might be regarded as industry, but not the latter. The very idea underlying the entrustment of the duties and functions to local bodies is not to take them out of the sphere of industry, but to secure the substitution of public authorities in the place of private employers and to eliminate the motive of profit making as far as possible. The levy of taxes for the maintenance of the service of sanitation and the conservancy of the supply of light and water is a method adopted and devised to make up for the absence of capital. The undertaking of the service will still remain within the ambit of what we understand by an industry, though it is carried on with the aid of taxation and no immaterial gain and no immediate material gain by way of profit is envisaged. This is a very powerful statement, but I think I'll pause here for a minute because both city of Nagpur, which follows Banerjee, and Banerjee follows all those earlier Australian judgments, which go on to say that municipal activities need not be necessarily kept out of the purview of an industrial concept. Now, if today they kindly again read that paragraph, at the middle of the paragraph, the very idea underlying the entrustment of such duties of function to local bodies is not to take them out of the sphere of industry, but to secure the substitution of public authorities in the place of private employers. Now, we have a long history of municipal corporations, both in England and in USA, where there are private charters given to municipal corporations. You are a body of inhabitants, you have a corporation where you have some charter, you undertake all those activities. But when you move away from a private charter, where a body of inhabitants may do whatever they need to fulfill their needs, to a body created under law, with a certain constitutionally or legally, created mandates, then would you not think that there is a paradigm shift in the very basis of removing from a privately managed affairs, which now being managed and discharged by public authorities? So there is somewhere, I find in the course of the discussion, both in the city of Nagpur and in Banerjee, the court falls for a consideration, whether it is private or public, it does not matter, as long as it satisfies human needs and wants by whatever arrangement it happens, they would definitely fall within the scope of an industry. I'll take your lordships to Subbarao judgment in Nagpur a little later. So kindly now turn to paragraph 34.
34 to 44 is a reference to the domestic law at that time. 40 up to paragraph 44, the lordships are referring to the previous judgments of this court.
Yes.
Right.
And 45 onward, then there is a reference to the international viewpoint.
Correct. I thought I'm going to, for my purposes, I'm not going to focus so much on clubs and associations, etc. That's on a different footing altogether. My focus is primarily on these functions, which would be now assigned to what constitutionally are legally mandated field of activities. And number one, and number two, where the both the 82, I'm sorry.
Sense of democracy at the grassroots level in terms of the constitutionalism now.
For instance, we have the 11th and the 12th schedule. Panchayats and municipalities that are now called upon to discharge several public utility functions. So my focus mostly on that. But before I go that, I don't think the new code in any way, directly or indirectly, echoes, I may say that, echoes an anti working class stand at all. It says, it captures paragraph 140 very lucidly. At the same time, I want to take some kind of concern to say what would not necessarily fall into a definition of industry, the kind of sovereign function that, though it says activities relatable to sovereign function. The new code could have gone into Bangalore water supply or any treatise on what is sovereign function today, but it does not do that. It cannot possibly, a legislature could not have enumerated what for all time would be a sovereign function. And therefore, it says sovereign functions, activities relatable to sovereign functions. Therefore, that would be an outer fringe, the penumbra of sovereign functions, where an outer fringe of activities may also be so relatable and therefore would not be included. Therefore, the new code I find has very, very carefully guardedly phrase this definition. So please keep that in mind. And we go to paragraph. I want to read a few more paragraphs to find out why is there a common running thread. The common running thread, as we find in the ultimate paragraphs of judgment, is systematic activity, no doubt, no difficulty at all. Employer-employee, can't be any difficulty. And then if there is no profit motive, there is some issue somewhere. So when you come back to paragraph 140, where it talks about distribution of goods and services. So distribution of goods and services is a gray area where we can have a room for disagreement and what kind of services and what kind of service. Suppose I have a ICMR and then there are even rice research. So the areas of research where they are directly geared to a certain supply of services directly and indirectly, and to enhance, let us say, community health. We have hundreds and hundreds of programs today, both at the central and the state government level, towards child nutrition, and then, for instance, and maternity benefits, so on and so forth. I got a large number of the list of those programs, and they are meant to be in support of advancing many provisions in the directive principles of state policy. So we have those difficulties when you talk of production distribution of goods and services. That's why I was trying to tell your lordship that the word undertaking has probably led to a large amount of discussion on whether some activity would be an undertaking or not. And there you again fall into the question of nocita sources, ejusdem generis. And let me please keep all that in mind. Paragraph 34 at page 30. In short, trade embraces functions of local authorities, even professions thus departing from popular note. Another facet of the controversy is next touched upon. That is, profit-making is not a sine qua non of industry, functionally or definitionally. For these powers, they in federal, municipal, so and so, considered an industrial, with empirical approval with the Australian High Court, considered an industrial legislation. Then I read it a little later, because when you talk about municipal city of Nagpur and Banerjee, this may have some bearing.
Para 44 Nagpur discussed.
Yeah, paragraph 38.
44.
37 and also 38, because the court enters into a little dense domain of drawing lines, but then it does draw lines. Para 38. 1 minute. Yeah, para 37. The limiting role of Banerjee must also be noticed so that a total view is gained. For instance, analogous to trade or business cuts down undertaking, a word of fantastic sweep. Spiritual undertakings, casual undertakings, domestic undertakings, war waging, policing, justicing, legislating, tax collecting, and the like are prima facie pushed out. Wars are not merchantable, not justice saleable, nor divine grace marketable. So the problem shifts to what is analogous to trade or business. As we proceed the next set of cases, we come upon the annotation of other expressions like calling and get to grips with a specific organization which call for identification in several appeals before us. Fortunately, as we see the new code, it doesn't borrow the old code, trade, business, undertaking, etc. It now essentially takes into account what is available in paragraph 140. Therefore, post the new code, the question of what will be an undertaking need not deter the code unless by forensic ingenuity at the bar, we try to bring it back and say, well, undertaking can always be loomed large behind the definition of industry, even in the new code. So I read paragraph 38 now. At this stage, a close-up of the content and contours of the controversial words, analogous, etc., which have consumed considerable time of counsel may be taken. To be fair, the pathfinding decision which conditioned and canalized and fertilized subsequent juristic humanistic ideation, we must show fidelity to the terminological exactitude of the similar expression, use and search carefully for its import. The precise words are branches of work that can be said to be analogous to the carrying out of a trade or business. The same judgment is negative, the necessity for profit motive and included charity impliedly has virtually equated private sector and public sector operation and has even perilously hinted at professions being trade in its perspective, the comprehensive reach of analogous activities must be measured. I ask myself the question, is it possible for the court to have such a measure at all, except to a certain limited and agreeable extent, where there can be a broad agreement? That the similarity stress relates to the branches of work, and more the analogy with trade or business is in the carrying out of the economic adventure. So the parity is in the modus operandi, in the working, not in the purpose or of the project, nor in the disposal of the proceeds, but in the organization of the venture, including relations between the two limbs, namely labor and management. I think that is why in the new code, this aspect of the definition, which is thought to be filled in here, is very wisely avoided. If you look at parity is in the modus operandi, not in the purpose of the project, nor in the disposal of the proceeds, but in the organization of the venture. So you can probably bring in many things by applying this very widely stated proposition. If the mutual relation, the method of employment, and the process of cooperation in the carrying out of the work bear close resemblance to the organization, method, remuneration, relationship of employer and employee, and the like, then it is an industry, otherwise not. An activity-oriented, not motive-based analysis. Is it, I sometimes wonder, with all humility to the learned judge, whether this not motive-based analysis is also a very sweeping proposition. Then we have paragraph 40. 44, I come to. Paragraph 44 at page 34. But I think it's also useful to read in the previous paragraph at the top of that page 34, the previous paragraph 43. It begins like this: filling the gaps in the Banerjee decision and the authoritative connotation of the fluid phrase analogous to trade and business were attempted to these twin decisions. To be analogous is to resemble in function relevant to the subject as between like features of two apparently different things. So some kinship through resemblance to trade or business is a key to the problem, is a guide star. Partial similarity postulates selectivity of characteristics or comparability, wherein lies the analogy to trade or business is then the query. As a court further to get on into the query, I think the query is only partly answered. Because the query could not be finally answered at all. The query could be answered on a given set of factors which present, unless we have some fundamental postulates on which there can be no disagreement whatsoever as to what would constitute an industrial activity. That's why I think both the 1982 and the new code picked up 140, paragraph 140. So those postulates are very clear. In the context of a trade or a business or any similar activity, you will have a systematic activity, an employer and employee, and the production or distribution of goods or services. But then if you pick up any one of an isolation, then there could be a problem. If you look up in isolation only a production, distribution of goods and services without reference to the other thing, that could be a problem. If you close your eyes to the nature of the activity, sometimes that could be a problem. Therefore, these are imponderables which you cannot be put into a box which you can seal them forever. Now let me read para 44, page 34. That Subbarao, with uninhibited logic, chases this thought and reaches certain tests in Nagpur municipality. Speaking for a unanimous bench, we respectfully agree with much of his reasoning and proceed to deal with the decision. If the ruling were right, as we think it is, the riddle of industry is resolved in some measure. Although foreign decisions, words and phrases, lexical plenty and definitions from other legislations were read before us to stress the necessity of direct cooperation between employer and employees in the essential product of the undertaking, or the need for the commercial motive of service, the community, etc., as implied inarticulately to the concept of industry, we bypass them but marginally persuasive. The rulings of this court, the language of the scheme of the act, and the well-known canons of construction exert real pressure on our judgment. And in this later process, next to Banerjee comes Corporation of Nagpur, which spreads the canvas wide and eliminates the expression analogous to trade or business, although it comes a few days after Hospital Madhu Sabha decided with the same bench. I see.
Seven, 48 and 51.
After quoting at page 45, sorry, or page 35, quoting from an ILO on freedom of association at the bottom, at page, paragraph 47 at page 35. This divagation was calculated only to emphasize certain fundamentals in the international industrial thinking which accord with a wider conceptual acceptation for industry. The wings of the word industry have been spread wide in section 2J and has been brought out in the decision in Corporation Nagpur. That case was concerned with a dispute between a municipal body and its employees. The major issue considered was the meaning of the much disputed expression analogous to the carrying on of a trade or business. We find that the text itself did not have that word. Therefore, when you want to read what the meaning of an undertaking, you have to find out some kind of a step book to find out what expressions, words, and principles can be used for the purpose of determining what is undertaking. Therefore, the major issue considered was the meaning of the much disputed expression analogous. Municipal undertakings are ordinarily industries, as Baroda Borough Municipality held. Just make a note here, Baroda Borough Municipality follows Banerjee. And even so, the scope of industry was investigated by the bench in the city of Nagpur, which affirmed Banerjee and Baroda. The court took the view that the words used in the definition of prima facie or the widest import and declined to curtail the width of meaning by invocation of no-citer sources. Even so, the court was disinclined to spread the net too wide by expanding the classic expressions calling service, employment, and handicraft. To be over-inclusive may be impractical, and so while accepting the enlargement of the meaning by the device of inclusive definition, the court cautioned. But such a wide meaning appears to overreach the objects for which the act was passed. It is therefore necessary to limit its scope on permissible grounds, having regard to the aim, scope, and object of the whole act. If therefore the court was looking at calling service, employment, and handicraft not to be widely seen, I suppose even the word undertaking, which must take color from trade, business, etc., you spread the net very wide. And for that purpose, you call what is analogous to trade and business. And therefore, that's a problem where this court tries to face and tries to answer in its own independent way. Then paragraph 50, 51, 51. Page 50, sorry, paragraph 50 at the bottom of page 36. The court proceeded to carve out the negative factors which, notwithstanding the literal width of the language, the definition must, for other compelling reasons, be kept out of the scope of industry. For instance, sovereign functions of the state cannot be included, although what such functions are has been aptly termed the primary and inalienable function of a constitutional government.
We need not to go into these. Because at that time, whatever the globally the jurisprudence was developing, that has been referred to. So you take note of that.
Yes.
Coming to the conclusions drawn, and then would like to have your own notes here. Questions to.
No, I thought a little more reading, I'll conclude, because it goes on how to iron out the creases and what is felt the absence of certain factors in the definition. And then the court says, what is the statute we are looking at? It is a worker welfare oriented statute. And therefore, the purpose of the act must be so fulfilled in order that I do not truncate the mission of the act. So while doing so, whether the court probably drew a line somewhere which continued activities would not be in the nature of an undertaking analogous to trade or business, and also while looking at functions which are now essentially what I may call constitutionally mandated public purpose activities, which are now drawn through different parts of a constitution. And most importantly, we say in the Schedule 7, your allocation of legislative functions and administrative, executive functions, you find a whole lot of them, which perhaps would not fit in with the old narrow concept of sovereign functions, inalienable, etc. For the concept of sovereign functions, even though it has been retained in the new code, it will receive its color from an entirely new conceptual way of understanding those, what I would call again repeatedly, constitutionally mandated fields of activities where the determination as to in what way I will exercise these activities, in what way I will pursue these activities, and in what manner for the purpose of executing them, I will have a certain framework. It could be an establishment, it could be directly done, it could be indirectly done. Therefore, when we enter into that, to say that in paragraph 50, where it said the primary and inalienable functions of a constitutional government, we go back in point of time to what was originally in international law, sovereignty concept, and again between state and states, or we again fall back in the judgment I will read from Nagendra Rao, in the field of civil law, torts. We have moved far away from the act of state principle. Therefore, the state is liable for a wrong committed by a servant or an employer, but they are in the field of civil wrongs. But when we come to an entirely different domain of activities where in the exercise of its, I said, constitutionally dictated functions, whether you could probably truncate and confine, a crib cabin confine, as I may call it, the sovereign functions aspect and go back on very historically outdated understanding. That's why I thought I'll read paragraph 50. Yeah. Kindly turn to paragraph 51. I'll quickly read through some of them. I was 51. Although we are not concerned in this case with those categories of employees who particularly come under the department's charge with the responsibility.
Conclusion of this, then for the rest of it is after this, education, all these things individually start. We don't.
All these paragraphs are ultimately crystallized
I'm
in
sorry.
paragraph 140, 141 onwards.
Correct. It crystallizes. I thought some
Not
plans.
position on the conclusions of the judge bench.
I'll immediately come to that, but why I thought some paragraphs need to be read is, what was the thought process which went into the mind of the court in saying, what do you pick up from each one of the judgments? Do they have a connecting thread? Is there a connecting thread available in all these judgments? So that ultimately I find out what are those connecting threads which I can call out as principles for the determination or the definition of industry. So these are very important milestones with the court to cross.
Just highlight them, that's all.
140, paragraph 140 is actually connected.
I'll come to paragraph 140. Page 73. Page 73. Industry as defined in section 2J and explained in so the wide report. So these are three principles with the court calls out from this decision as on their analysis. But then B, C, D, I think let us look at it. Absence of a profit motive or gainful objective is irrelevant, be the venture in the public, joint, private, and other sector.
It may not be also. But they say there is.
Subpara C seemed to introduce a little nebulous issue and probably dilutes the other three earlier parts. The true focus is functional and the desired test is the nature of the activity with special emphasis on the employer-employee relationships. Then if the organization is a trade or business, it does not cease to be one because of philanthropy animating the undertaking. Then para 141. Although section 2J uses words of the widest amplitude in its two limbs, their meaning cannot be magnified to overreach itself. Then A, undertaking must suffer a contextual and associational shrinkage as explained in Banerjee. And so also, I think there is, Banerjee perhaps does not go on the same wavelength as this. So also service, calling and the like. This yields the inference that all organized activity possessing the triple elements in one supra, although nature of business may still be industry, provided the nature of the activity, namely the employer-employee basis bears resemblance to what we find in trade or business. So do we have a magic test to do that? On the one hand, it says, well, yes, though triple test is they call. On the other hand, the court goes on to say, probably the employer-employee basis in every such activity beyond or even a trade, there will be some employer, some employee. So that seems to have brought in a greater emphasis and focus on this nature and the employer-employee basis, bears resemblance to what we find in trade and business. There can be today activities where this resemblance may be completely absent. But there is some employer-employee relationship. And there could be an organized activity. And this takes into the fold of industry undertaking callings and services, adventures analogous to their carrying on the trade of business. So in his anxiety to leave no room for any doubt, Krishnaya just goes on to say, adventures analogous to the carrying on of trade and business. So all features other than the methodology of carrying on the activity, namely the organizing, the cooperation between employer and employee, be dissimilar, it does not matter. If on the employment terms, there is analogy. So ultimately, this seems to be the fundamental premise or a thread which will inform any discussion even in future on what would be an industry, notwithstanding the departure in the new code of 142. Application of these guidelines should not stop short of their logical reach by invocation of creeds, skulls, or inner sense of incongruity or outer sense of motivation for the resultant of the economic operations. The ideology of the Act being industrial peace, regulation, resolution of industrial disputes, employer and workman, the range of the statutory ideology must inform the reach of the statutory definition, nothing less, nothing more. The consequences are professions, clubs, educational institutions, cooperatives, research institutes, charitable projects, and other kindred adventures, if they fulfill the triple test listed in so and so, cannot be exempted from the scope of section 2J. There's some kind of a circularity I find here because I said the employer-employee nature will be important, then even if the other three tests are not so important. But if in a restricted category of professions, clubs, cooperatives, and even gurukulas and little research labs may qualify for exemption if in simple ventures, substantially and going by the dominant nature criteria, substantively no employees are entertained, but in minimal matters, marginal employees are hired without destroying the non-employee character of the unit. I pause here for a minute. There have been cases where, and the Contract Labor Act, so that it's been alleged that employees, in order to avoid the Contract Labor Act implications and application, you employ just persons less than 10. So the Act does not apply. These are devices. Of course, those devices will always be identified and said they are illegal. So I don't know whether that will probably help us anywhere here. If in a pious or altruistic mission, many employ themselves free of a small honoraria like return mainly drawn by sharing in the purpose or cause, such as lawyers volunteering run of legal services, clinical doctors serving on their spare hours in a free medical center or ashramites, working at the bidding of the holiness, divinity, or like central personality, and the services are supplied free on a nominal cost, and those who serve are not engaged for remuneration on the basis of master and servant relationship, then the institution is not an industry, even if stray servants, manual or technical, are hired. Such eleemosynary or like undertakings alone are exempt, not other generosity, compassion, development, passion, or project. Then the dominant nature test, where a complex of activities, some of which qualify for exemption, others not, involve the employees in the total undertaking, some of whom are not workmen in the as in the University of Delhi case, or some departments are not productive of goods and services. If isolated, even then, the predominant nature of the services and the integrated nature of the department is explained in the Corporation of Nagpur will be the true test. The whole undertaking will be industry, although those who are not workmen, by definition, may not benefit by the status. I find in the Corporation of Nagpur, virtually every department, every activity of the Department of Corporation of Kanpur, including a taxation department, an administrative department, so on and so forth. So the sword falls very broadly. So I don't know whether the Corporation of Nagpur, as in the context of municipal services, which now undertake an entirely different hue and color, should still be a good law. Now, notwithstanding the previous clauses, sovereign function, strictly understood qualify for exemption, nor the welfare activities or economic adventures undertaken by government or statutory bodies. How do we really therefore say what is a welfare activity or the economic adventure? So they will not qualify. So even in the departments in discharging sovereign function, if there are units which are industries and they are substantially severable, then they can be considered to come with Section 2J. I have no serious disagreement with that question, provided a particular activity is essentially a trade, business, commerce, or industry within the core meaning of the Act. Then constitutional and competently enacted legislative provisions may well remove from the scope of the Act categories which otherwise may be covered thereby. This is what the new code has done in the penultimate clause. So we conclude with the difference because Parliament, which has the commitment to the political nation to legislate promptly in vital areas like industry and trade and articulate the welfare expectation, has hardly intervened to restructure the rather, please mark the word, the rather clumsy, vaporous, and a tall and dwarf definition or tidy up the scheme, although, which means Section 2J as it then stood was a vaporous, clumsy, and tall and dwarf definition. I think it will be a little adventurous on a part to say that, even though it was clumsy, let us say, but then vaporous because you want to connect trade, business, and undertaking. You want to connect and charitable activity.
2 lines below. The court was informed that a bill is in the offing.
Correct.
Right? Therefore, the court had to clear the doubts in present time.
I'm not disagreeing on that question. I'm not saying anything about that. I'm only saying that the court from Banerjee onwards, was laboring hard to find out if I can give some electable meanings which will satisfy the anti-exploitation genius of the Industrial Disputes Act, the anti-exploitation threat, which runs entirely through this act. So if they're trying to find out what will be all those meanings which can be probably go into the understanding of industry, because the court finds it is clumsy, vaporous, and so on and so. Not that I'm happy with this, but of course, to a considerable extent, the definition has some vague elements. I was recently reading a piece of literature on there's a need for something not to be specified in some parts of law, room for non-specificity. That comes because if you define too much, if you say too much on a particular word or an activity or a word or a meaning or a definition, then you stultify what exactly the law will operate. The organic, functional, operational parameters of a law should be left sufficiently wide enough. That's what they need for. We take the word in tort and vicarious liability and how it has evolved over a period of time. Then when even in this case on municipal sovereign function, the Australian judgment says, I don't want to use the word sovereign function. We go to the word regal and non-regal function. So you will find some word in English language. We have all these problems of every language. So how much of it can capture? So we have meanings which a word gathers over a period of time. Which meaning will be the most fittest meaning is always a job of both a legislature and the court. So I think this where it must stop. But I must read to your lordships also what Justice Beg and Justice Chandrachud has said. By and large, the judges, both the honorable judges, concur with Justice Krishna, yeah? And Justice Beg, just to add.
Justice Beg has broadly, by and large, you agree.
I want just invite Lord's attention to 2 or 3 paragraphs at page 77. Page 77, at that part of para 149 beginning from the previous page, line about 5 from the top. We have, so to speak, my
Substantial time.
let me place my points of view now one after another. So you continue, Lord. Right.
Yes, please.
So we have, on behalf of the workers and the working class, rightly so, we hear that the Bangalore water supply is correct law, and that it should be applied expansively, notwithstanding the new code, and that sovereign functions must be read restrictively. That's one voice which will be heard. Then on behalf of the state body, I find there are 5, 6 states which are here, where they're concerned with the forest department, the irrigation department, etc., being declared industry and things like that. So on behalf of the states, the submission will be the triple test in BWS is wrong, and therefore sovereign function should be read expansively. Then you also have charitable institutions like Pinjarapol. I would have taken lots of the Pinjarapol judgment with a lot of interest. So charitable institutions and research institutions, like many of them are here, like a space research, then ICMR. And here that they do not fulfill the triple test, and therefore the application of triple test to them was too overbroad. So we have three facets of this. So I think as far as the union is concerned, that as I analyze more and more the triple test, the tests are the factors which are interpreting the definition of industry as proposed by Bangalore Water Supply are logically correct because you're picked up from various judgments, namely employer-employee, right? There must be a organized activity. There must be a production of goods and services. Therefore, to that extent, is logically correct, and cannot be said it has an inherent logical fallacies. But nevertheless, the problem arises not in the question whether they're logically correct or not. Nevertheless, the application of these tests are factors. As proposed by the majority in the Bangalore water supply, I say has been probably is too over broad. In BW itself, you will find it. And therefore, an indiscriminate application of it leading to a over-inclusion of activities within the ambit of industry is going to be problematic. And therefore, the court is now probably called upon to clarify the application of these tests and factors, especially in the context of activities carried on by the state and other municipal bodies. May continue.
How much time? Because we had
And
given
around.
petitioner side, we had fixed 4 hours. So 2.5 have gone and.
I'll conclude in an hour's time. I thought by placing this very broad proposition,
Let's
many,
save, of
many
course, the other
concerns.
time. They need not to read out now judgments and all the things.
Yes.
They can straight come to their points. Will 10, 15 minutes be fine with you?
No, we have placed a written submission, all those judgments are there.
Now, 1 hour.
I just
Will
need
you
a
be able to set up in 10, 15 minutes after?
maximum, I try to conclude within an hour or so. I'll try to be as brief as possible.
Hold it. Please, because in para 4
I
and
know,
5
I understand that.
of our order of 16th February, we have fixed a timeline.
I understand.
We will request the parties to adhere to that. Thank you. Only 1 second there. You see, when we were requesting before lunch that all of you are requested to adhere to the time schedule.
Yes.
The other most important reason is that two very eminent senior advocates who are domain experts,
Yes.
two very eminent senior advocates and who are well known as domain experts, they have very kindly agreed to assist us as amicus in this matter.
Yes, yes.
So we at the outset express our gratitude to Sri J.P. Kama, Senior Advocate, Bombay High Court, and Sri P.S. Sen Gupta, Senior Advocates from Calcutta High Court, who both have very graciously have graciously decided to assist this court as amicus. So we will spare some time to sum up from both sides.
Therefore,
What is the true important?
like an obedient student.
You can sum up, Leonard.
Yes, sir. As it is like an obedient student, I'll try to conclude as early as possible.
Yes, please. Thank you.
So I don't propose to read the BWS in extenso again. That may not be required. But in terms of the issues which your lordships have framed, and as I said, the issue number one, broadly, my views are like this, that the triple test and the dominant nature test are factors which are in itself a good test to determine whether an activity may be categorized in industry under Section 2J of the 1947 Act. However, caution must also be exercised while applying these tests and principles, as not everything that answers the triple test ought to be considered as industry. Then it's important that the court struggle with the question of what could be included and what should be excluded. So the court is also trying to find out, can I locate some norms or criteria both for inclusion and exclusion? The court found it a difficult task. Ultimately, it was left to the legislature to do that. Therefore, certainly certain other factors besides the triple test would have to be necessarily, if they're relevant, a due consideration may have to be given to them, while alongside the dominant test and the functional test as well, so that there is no overbroad and indiscriminate application of the triple test principles. Then also, since the court underwent the whole exercise of considering undertaking whether analogous to trade or business, and weightage must be given to whether it is, the analogous is a very difficult, it's like a quagmire, you can't probably, quick standard can pull you down. So let's be very careful about it. Then on issue number two, when the government undertakes several activities, which are constitutionally mandated field of activities in furtherance of public welfare and public need. For instance, we have all those cases here, forestry. I read out the Condere judgment, which is a very classic case where Indira Jay Singh appeared, Mr. Dolaka appeared, namely forestry, irrigation, health, education, etc. And the list could be endless. So they cannot be excised prima facie presumed to possess the elements of trade, business, or commerce. And therefore, the simplicity of the application of the triple test in para 140 could be open to question. Then on issue number 3, the Bangalore water supply has gone by very bygone principles of sovereign functions and sovereign powers. Therefore, that conventional bygone understanding will not necessarily inform the court either in looking at BWS or even the current code. Therefore, the modern constitutional welfare state carries out various functions and activities that may not be limited to traditional sovereign functions. And then sovereign functions are evolving in over a period of time. Then ultimately the executive, my lord, just Nagaratna put a question, LPG. Now, in the context of changing in the economic situation in our country, globally and also. So what in the early 60s and 70s, the government thought, occupy industrial space by nationalization. So we had coal, iron, all those activities were nationalized and industries were set up, factories were set up. So that when you are departing from that, and the more of them today are in a private sphere, there's no difficulty as to whether those private spheres are industries or not. But if there are certain activities which are like a regulatory aspect, the regulatory aspect and the state will determine how far the regulatory aspects are important and the course of discharging those regulatory aspects. If the state will have employer-employee relationship, will you say because of that factor alone, a regulatory aspect being determined, set up by an establishment, it could be a facilitating initiative. So it's very difficult to draw a line saying in the regulatory aspect, facilitating, all will now go because employer-employee is there, therefore you will be in industry. That could be a very problematic area, and therefore, to that extent, BWS can be, if it's extended indiscriminately or without any moderation, that could be an issue. Then that's how I think I would answer these three questions. You kindly may request your lordships to, since the second part of the first question, please turn to my written submissions at page 81. So I was trying to understand and comprehend the relevance and the importance of the second part of the first question, which said the impact of the 1982 Act and the 2020 Code. So what kind of an impact these two legislative instruments can have on Bangalore water supply? So we have all those plethora of judgments which say that if a earlier law, which is ambiguities and a lot of issues regarding interpretation, open to multiple readings, multiple interpretations, then a law on the same subject or even a cognate subject, which comes later, can throw considerable light on the reading and interpretation of an earlier law, where within courts is open to multiple or various interpretations, readings. I'll place some judgment to that effect. Kindly come to paragraph 81. So in the written submission.
Paragraph?
Sorry, page 81. Page 81, paragraph 108. It is with reference to the second, the question whether the two acts, in answer to the question, second question, or second part of the first question, the submissions begin at page 79, but I propose to read at page 81.
Are you reading after the reproduction, it is submitted that?
Yeah, page 81, paragraph 108. 107 is, yes, that's right. It is submitted that it will be always open to Parliament to depart from the declaration of law in Bangalore water supply and to provide for appropriate legislative framework to deal with the distinct categories, class of employment and services, and also to provide for suitable dispute resolution processes. The exclusion set out in 82 amendment intend to remove various activities, whether by way of protection of goods or services, from the scope of application, in order that, or with a view that such enumerated exclusions deserve to be dealt with under some other legal framework. Place on record that on 12th of August 1986, the following questions read in Parliament. Then the Minister of Labour will be pleased to state whether in November 1985, then so-and-so indicated that government were considering to enforce the definition of the term industry as in so-and-so Act. The answer reads like this. In his letter dated 30th of November 1985, the Honourable Member, the then Minister of Labour, inter alia stated that a bill had been introduced in Parliament to provide an alternative grievance redressal mechanism for the employees of hospitals, dispensaries, educational, scientific training institutions, etc., who are being excluded from the coverage of the Industrial Disputes Act, and this has not been finalized. It's not possible at this stage to indicate the time likely to be taken in finalizing the matter. No estimates in respect of employees which would be affected are available. We may notice that the debates in Parliament during the introduction of the 1982 amendment with the intent to provide special legislation for excluded categories of employment. The relevant part of the debates is reproduced hereunder. Page 82. Government have received representation that we are unduly restricting the scope of the Act by excluding certain categories of employees from within the purview. Our members will appreciate that there is an inherent difference between undertaking, which in the commonly understood language fall within the definition of industry, and between hospital, educational institutions and research organizations. Although we have excluded these categories, the idea has not been to take away workers' rights in these sectoral activities, Because by and large, we have provided an alternative grievance redressal machinery in the hospital, in the institution will show it itself. We have received requests from several institutions and organizations engaged in sectoral activities, which come in the list of excluded categories, requesting to specifically exclude them from purview so and so, so and so. The next paragraph. The criticism is raised regarding the second part that it does not include institutions like hospitals, educational, scientific research, training institutions, and such other institutions. In this connection, I would submit to you that through you to the House that an establishment in Faridabad or a jute mill in West Bengal cannot stand and should not stand on the same footing as a hospital or a university. In an atmosphere of a hospital, the interest of the patient is there. In an atmosphere of university, the interest of the students ought to be safeguarded. This does not for a moment mean that the management of any institution can go scot-free if any action is taken by them which is detrimental to the interest of the workers. Therefore, I compliment the government for having already introduced a bill to deal with similar matters and such institutions excluded so and so. In this bill, hospitals, dispensaries, scientific research institutions, educational, as also charitable interests have been exempt in the purview of the bill, but I demand that the interests of the employees institutions should be looked after by government in whatever manner they like, proper and suitable. Similarly, the atomic plant, the defense research institutions have been taken out of the orbit of this law. It is stated that the government will bring forward a special legislation for the protection of employees in these institutions. Appeal so and so to so. That's how this hang on for a long time. So there was the para 111. However, as seen above, the excise did not fructify and the amendment was not notified and brought into force. The amendment remained as a stillborn law. However, even in such cases, notwithstanding non-notification of an amendment, alteration in the law, parliamentary intent behind the amendment will sail along with the purpose behind the amendment itself. Consequently, there is some room for an argument that the 1982 amendment may be used as an interpretative tool for the application of the test laid down in Bangalore water supply to the excluded categories. That's an open question, but I thought that's one way of putting it.
Now,
The
for
Industrial Relations Code.
for educational institutions, there are the state education acts where they provide the tribunal with regard to dismissal, reduction in rank, termination,
Correct.
discharge,
Correct.
labor, you see, problems, not labor exactly, the employees' problems. Yes, service. Education service. Education service criminals, yes.
Because every state has got an education code, governs teachers, schools, colleges. To that extent, there is a mechanism available for redressal of grievances. So then I further read, there's one judgment, a couple of judgments I would like to place your lordship's consideration in this context. Is it available in the court?
This one, and then this.
There is considerable literature and judicial precedents on the subject as to whether there is a, as I said earlier, an amendment or a new law, and it finds that an earlier law has considerable ambiguities, open to multiple interpretations, and the later law tries to navigate those problems, and it offers a way of looking at an earlier law. The court always says the later law, by way of whatever amendment or otherwise, can always be looked into as an interpretative guide. Not necessarily a final say on the subject, but it will say, therefore, courts will always use them. A number of judgments, only I thought I'll cite one judgment. This 2014 9 SEC 2121. No, para 9. The question here is about between the Arbitration Act of 1940 and the subsequent amendment. Kindly turn to paragraph 9 at the page 219 of the report. Just around placitum E, paragraph 9. The change in the legal approach towards arbitration and alternative dispute resolution mechanism is perceptible both in regard to the requirement of giving reason, etc. While in regard to requirement of giving reason, the law has broad the limit dimensions not found under the old act. The scope of interference appears to be shrinking in its amplitude. No matter judicial pronouncement at time appear to be heading towards a more expansive approach that may appear to be some to be opening up areas for judicial review on newer grounds falling under the caption so and so. We are referring to these developments for it is one of the well-known canons of interpretation of statute that where an earlier enactment is truly ambiguous in that it is equally open to diverse meaning, the later enactment may in certain circumstances serve as a parliamentary exposition of the former. Then para 10, in Yogendranath, this court held that a subsequent legislation, the same subject, may be looked into with a view to giving a proper exposition of a provision of the earlier act, borrowing the principle so and so reasonable to hold obligation cast upon arbitrator. Let's say we'll give the citations.
Under 2024.
No, I think we should give these citations also. Give them with me. There are two more judges. We'll also just make a note of it. I don't propose to trouble reading this. Huh? Which one? Vanish.
And also you can, this also.
These two judgments, the one in 1984, 3 SCC 46, whereas 20 to 23 in 84. Then the next judgment, 1969 1 SCC, 555, paragraph 7.
Paragraph numbers and both judgments.
Can you give the para numbers? In the first judgment, 84, sorry.
This one is okay. In the Ansham, para.
Para 20.
Paras 20 to 23.
All right. Interpretation.
This is referred to in paragraph 9 of the first judgment.
That's right. Then in the other judgment, 69 1 SCC, it's paragraph 7.
Understand?
That was from the Japanese.
Is sir?
7. 7. 7.
7. And did I see? May proceed further. Page. In the written submissions, para 112 and 113, kindly make a note of them. Para 112 is a reproduction of the new code, but it says
Learned attorney, we will not rely upon the definition in the new act. For the simple reason, there is already a caveat put in from the other side, that there might be a challenge to the 2020 Act.
that's right.
So, of course, the principles which you are referred to, particularly 1969 judgment,
Yes,
this is one of the tools for interpretation.
that's right. I'm not.
There
These are.
and
You're logically right, because when you're confronted with novel areas of debate and disputes,
thousands of tools. So
Right.
this one we might consciously will intend to skip this.
yeah,
Because then we don't want to comment on that.
that's right. Then para 113,
Yes.
at the bottom of page 83, which I began with my submission in the footnote. So we'll guide the adjudication of disputes arising pending before so-and-so. All disputes are governed by the Industrial Relations Code 2020. Then kindly on the sovereign function, I have some more submissions to make. In my written submissions, how for long we have been struggling with the question of in the civil wrongs, vicarious liability and all that. And we don't get into that because that happens in an entirely different domain. It may or may not definitely throw a light on sovereign function in the context of what I call constitutionally mandated activities being undertaken for public welfare. So whether from that old English.
And all disputes arising.
What man?
Correct.
Not learned attorney. And particularly under this head of G.12, consideration of sovereign function in industrial law. I think that explain your viewpoint.
That's right.
His 3.12 is history.
3.12, the entire history.
Nagendra Rao,
Yes. So my only concern to just as of now is to deal with the sovereign functions issue. And as we discussed, that if for more than 1950 to 78, courts have been trying to very courageously find out the good meaning for the word definition of industry. And therefore, in that context, if a new law can throw some light, the court will not see it, use it as a statutory instrument, will not apply it, as it is called ex proprio vigor the application, but use it as an interpretative tool to find out whether in a given case, this will throw some light for adjudication. Now, for the 19, in the context of the second part, the first question you also framed, whether these two acts will have any impact, I think that's the way the impact can be looked at. And if you are right in saying that prior to 2025 and between this period, if the triple test plus all the other additional inclusions and the caution required in applying the triple test, that will be the law during this period. Post 2025, of course, the new code will take over. So to take charge of the period between 78 to 2025, I think it will be important to keep all of them as a corpus of principles so that courts which are called upon to deal with them, apply them and resolve them. So may I come to paragraph page 897, because from 84 to 96, we have traced out the history of sovereign functions in distinct domains, legal domains.
So according to you, sovereign functions must be narrowly interpreted now or broadly?
No, there has been ambivalent. That's why, for instance, if I look at a judgment in 2019, which I quoted at page 96. So the question is, we seem to have as I said, an ambivalent understanding. So it seems that the definition of industry in BWS, you seem to be having some kind of a shadow on many of these considerations and concepts. That's very evident in, for instance, at page 96, the 2019 judgment. We thought I'll place it for as a way of illustration. So we have two distinct contexts in which this has happened. One is the Consumer Protection Act. That's why 2019 comes. And the another is the Competition Commission context, where sovereign functions get to be discussed. We just make a note of it at page 96, paragraphs 126 and 127.
Come back to this.
I think, we think under the head of G2, you have summed up by saying that these sovereign functions cannot be put into a stated jacket
That's right.
formula.
That's right.
And then 128 probably illustrated.
Exactly. Because the need why I thought we'll put the sovereign functions debate in distinct legal domains like civil wrongs, consumer, competition. And so I thought this would be one possible route through which we can conceptualize sovereign functions and therefore in future when the new code will have to be interpreted. Because I did not find in the Bangalore water supply a particular instance. The water supply itself was, the court said, did not say it.
Itself doesn't have that.
Correct. Because it followed extensively city of Nagpur. And then affirmed Nagpur and then overruled Sabdajang. So if the, on the canopy of sovereign functions, city of Nagpur has been affirmed. In my view, probably city of Nagpur has been wrongly affirmed. Because virtually the city of Nagpur, all the departments of the municipality have been held to be industries. Almost all of them. So, including a tax department, an administrative department, so a fire department. So therefore the question is, if today the nature of a municipal function which is under a statute and can be necessarily determined both from outside and internally, so would you say every activity of a municipal establishment would be an industry? So as long as within that law, there is sufficient safeguard for an employer to have remedial process available. So that will be a safeguard. Certainly without a safeguard, you can't have a law. You can't say it will be left open for vagaries of employment opportunities and context. Certainly not. So therefore, city of Nagpur is affirmation seems to be an overbroad affirmation.
Then the only remedy is by way of a suit. Or if it is if it is a Article 12 established, you see, instrumentality or agency of the state,
Correct.
then possibly Article 226 remedy is there.
Correct.
Otherwise, it will only by a way of a suit. Now, the such employees are covered. Service tribunal.
Most of the states are now there.
Let me lean
Or another suit.
for the sake of argument. Let me lean in favor of the most comfortable process which a worker would like to have, in order there is no uncertainty in the conditions of employment. Certainly, the answer must be in their favor. But today we have a large number of enactments which are regulatory enactments, which have occupied the field of employment even in private sector. Large number. Therefore, the need for collective bargaining, which was so important in the early days of industrial jurisprudence, is now largely occupied by enacted legislation, policies, schemes. So in where they do not exist at all, then comes the question, what is the remedy available to them in order that their conditions of employment, termination, retrenchment, etc., should not happen in an arbitrary, whimsical way. Therefore, that's the way one should look at it. So we have gone far beyond that. I looked into the larger number of legislation post 1978 and pre 1978. So, for instance, the construction workers' welfare legislation, the most progressive legislation which has been enacted in 1982. So we have crossed all those early days of the need for essential, inevitable need for collective bargaining. When the state is absent-minded on certain issues, of course, it will be a call for a debate. So kindly just look at submissions in page 97 to 99. Page 97, paragraph 130. Let me, you not permit me to read a couple of these paragraphs here. So para 129, the jurisprudence outlined above reveals the fundamental principle, the nature of sovereign functions inherently linked to the evolving role of the state. Activities that may not be once considered uniquely governmental could subsequently move to the realm of private enterprise or through public-private arrangement. Conversely, new forms of governmental responsibility may emerge because of technological, economic, or institutional developments. For instance, look at the forestry issue by itself. Today, it's not merely a question of taking care of a watchman to take care of forest. It has become a national concern. So sustainable development, precautionary principle, so on and so forth. So if there are certain national concerns, community concerns even in some section of the community, so how do you, it can't be left open to a private enterprise to come and say, I will do this. It requires today a large number of private activities to be essentially regulated by governmental and state regulations, either a policy or a scheme or a law. I can't say I have a right to carry on trade and I can carry on a trade on timber. You can't do that. You can't say I have a property owner of a land and I can alienate my land the way I want. You can't do that. Therefore, large number of legislative regulatory frameworks have encroached on many of our rights. So most particularly in the realm of industrial jurisprudence. So that must be therefore kept in mind. If you therefore shackle the powers of the government and to say that sovereign functions be only minimal, those inalienable functions like defense, arms, etc., I think that will be a very narrow way of looking at it.
No, but the idea is to exempt sovereign functions. So whether the exemption must be read strictly or narrowly?
Yeah, that's right.
Broadly.
Broadly. I'm not asking the court to enumerate, and I think neither the legislature will do that, nor the court is going to do that. I'm not saying that. I only say that the 2020 code, that's why I said repeat, has been very wisely said. Activities relatable to sovereign functions. 82 also say that, 20 also say that. So there are two components in the 2020 code. What are sovereign functions? So what are sovereign functions? Open to question, but somebody can come and say this is a sovereign function. An activity can be relatable to a sovereign function also. So it is both relatable to and as well as sovereign function. The new code takes care of that, the necessary width to be considered.
Leads to Jagannath Konduri like situations where forest department gets declared an industry.
In paragraph 141.
Yes.
Run it.
131 and also,
But before that, I need to read this.
One or the conclusions.
so paragraph 134, we have said, what are those things?
Brother has asked you. Issue number one, of course, you deal with Bangalore water supply and then social welfare activities and their impact. And the next one deals with
You're not reading at page 101?
regime. Issue number 1, 2, 3.
Yes, yes.
Para 141.
Yeah, let me read it. In the triple test laid down in Bangalore water supply is a good law insofar as determining industry under the Industrial Disputes Act. The 82 amendment may be used as an interpretative tool to avoid overbroad interpretation and indiscriminate application of the triple test to identify an organization industry. These interpretations will be applicable to all cases pending on final trial to so-and-so, and after which the Industrial Relations Code came into force and shall be accordingly applicable. Issue 2, social welfare activities and schemes or other enterprises undertaken by the government department representatives cannot be construed as industrial activity for the purpose of so-and-so. Caution must be taken while applying the triple test to different activities, especially in relation to charitable organizations and government departments carrying out sovereign functions, government functions, constitutionally mandated functions. Then 3, modern Indian state is not confined to traditional sovereign functions such as defense, maintenance, the public order, administration of justice. Rather, it operates as a welfare state tasked with implementing wide-ranging social, economic, and development policies. Such activities undertaken by the state frequently involve organizational or operational elements that may superficially resemble industrial or commercial undertakings. However, such incidental operational aspects deserve closer scrutiny and cannot be isolated and treated as independent industrial activities, which may undermine the broader governmental purposes. So, thus, given the ever-evolving nature of state function, this Honorable Court may also recognize that executive is institutionally better positioned to determine any activity as sovereign function and restrain itself from exhaustively defining the same. Judicial reviews, of course, remain available to ensure executive determination is not arbitrary or inconsistent with
Here you have summed up very well that this is what probably you wanted to communicate in all these paragraphs.
I also want to make a final submission that since the back Nagpur has been affirmed, probably my stand would be that Nagpur, to a considerable extent, is not good law. Because it says everything municipality is all industry.
Thank you, Mr. Adani.
And I would say, therefore, today, I say a large number of midday meal schemes and Anganwadi workers and constructing, there are canals in Kerala which are built only for a particular period. So your private party cannot say, I'll build a canal or have a network of irrigation team. It's entirely up to the government to decide where a canal will be laid, for how long it will be laid, what will be the investment, so on and so forth. Therefore, large number of such governmental activities today, they can't be tested only on the principle whether it can be otherwise, undertaken by a private party. That test seems to have some brittleness about it. That test of whether a private party can have, therefore, if it can be undertaken by a government, it can be an industry. I say there is some brittleness about the test. That of course, where Nagpur went a little too overdone.
So we appreciate the efforts done by the assisting team, whose names are also mentioned in your note. We acknowledge their
yes.
hard work and.
Yes. May only place one mapping which you have made on the various principles which Bangalore water supply is undertaken, and then they emanate from which earlier precedent, so that it will be useful. Give it to the court.
Mrs. Nagarkar asked for.
Yeah, we have copies. Copy.
Because we have got this one.
Thank you. many copies?
This is for us.
Yeah, okay. Half a minute.
So like, we'll keep it in mind.
All those, para 140 retrace the entire case law. Right? Then just Nagaratna asked me a question in the forenoon about the common and the different parts of the three definition, 2J 1982. And so we have just worked out so that what is for the court. How many copies?
Only.
All right.
Yes, compare it.
So the common ones are colored in green and the different ones are colored by blue. Sorry.
So we should not get mixed up.
Definition.
Common is green.
Okay. On to the next page.
The law is not, is colorblind. I'm grateful for your lordship.
Thank you, Mr. Ranjan. Thank you.
I hope para 141 and article 141 is.
Why you have so much teaching? Yes.
That's it.
Monster.
I thought sure. After me, please. Please. Here, state of Uttar Pradesh. That's the lead matter actually. Let's see.
Jabir Singh.
Please.
Yes.
And I'm also conscious of the time indicated to me.
And in any case, now learned attorney has
I'll
now
stick
the
on to it.
judgments, provisions, so state we can start with that.
I given a short note, although we have filed a separate detailed written arguments, but need not refer to that. I given a very short note for the purpose of consumption today.
Yes.
You kindly have a look at the written note which I given today. Very expansive interpretation has been given in the Bangalore water supply case. Therefore, in order to remove certain ambiguities or the practical difficulties, the legislature initially brought 1982 legislation, although it was not notified. And now again, 2020 legislation has been brought in, giving certain definition to the industry. Now that has to be taken as an indicator for the purpose of interpretation of the definition, which stood then also, or to the pending cases.
Yeah.
The present legislation and also 1982, which has not notified, that can be taken as a clarificatory legislation, although it is not actually the clarificatory legislation, that can be taken as a clarificatory legislation to understand the meaning of industry, which has been done in 1978 judgment.
So the 92 amendment sort of restricts the
Correct.
judgment,
Absolutely.
limits.
Limits.
Attempt was to limit.
Yeah, attempt was to remove. So you have to take it as a clarificatory tool to clarify the difficulties or the ambiguities which it stood by way of the interpretation made in the judgment of Bangalore water supply development case. Now, by taking it as a basis, now I have formulated 3 points for consideration in second page. In para 4, the first one is the subsequent legislative developments, including the unnotified amendments and the enactments of the Industrial Relations Code 220/20, may be read as a clarificatory in nature, reflecting the intent of Parliament regarding the scope and ambit of the definition of industry. That is the indicative of the legislative intent, why that was brought in, especially having considered the ambiguity and the difficulty which the country faced by taking the interpretation which has been made on the basis of the erstwhile Act. That is the first one. The second one, the concept of sovereign functions ought not to be understood in a narrow colonial sense, but must be interpreted in the context of constitutionally governed democratic state. In the judgments or till such a time how it has been understood, the sovereign function was in the colonial sense, that I will explain in the subsequent paras. That cannot be the approach. That has to be understood in the Indian context, how we are governed or ruled by the constitution and the democracy. It has to be understood in that context. Third one, the interpretation must also consider the consequences that follow from an overly broad construction and the need for an appropriate balancing competing considerations, that both the employer and the employee, the competing interests will have to be properly balanced while giving the definition to industry. We can't give a very sweeping definition to the industry which has been given in the Bangalore Development Authority case. Now, insofar as the first issue is concerned, definitely I am very cautious of the caveat put by them that we are not called upon, we are not defending anything with regard to the legality of the new legislation. But however, my argument is the subsequent amendment that has to be taken as an indicator of the legislative intent, what they wanted to do having regard to the past difficulties which the country faced while implementing or taking forward the earlier definition. Now kindly go to the definition part of the 2020 legislation, which I have put in page number 3. The code defines industry as 2P, so and so. Now industry P1, the first para and 1 and 2, it has almost retained what has been said in Bangalore Development Authority case. Bangalore water supply case, that has been retained the P first para and 1 and 2. Thereafter, it does not include. The intent was, by virtue of that interpretation, the things which have been given in the previous paras should not be included, to say institutions owned or managed by organization wholly or substantially engaged in any charitable, social or philanthropic services, or any activity of the government relatable to the sovereign functions of the appropriate government. Kindly note, it is relatable to the sovereign functions of the appropriate government, which means not only the sovereign functions, but something relatable to the sovereign functions are also sought to be excluded. If the intention was to exclude only just the sovereign functions, they would have stopped. The categoric expression is relatable, which has a very, very wide or the wide expression, which something is connected to sovereign functions, those activities are excluded. Now kindly see the next one. Inclusive definition has been given thereafter, including all the activities carried on by the departments of the central government dealing with the defense research, atomic energy and space. So all the activities of defense research, atomic energy, irrespective of whether it's a sovereign or non-sovereign. When it comes to
defense, research, atomic, energy or space, whether it's a sovereign or non-sovereign, it is immaterial. Even if it is unrelated also, it is immaterial. Even if it is unrelated, they are kept out of the purview of the Act. The first part is relatable to the sovereign functions. The second one is in respect of atomic energy, research and defense, everything that has been kept out of the purview of the Act. That is the second part of it. This is the legislative intent. So that has to be, it has to be taken as a clue what the legislature wanted to interpret or wanted to apply to the scenario. And by keeping that mind, by taking this as an interpretive tool, we have to interpret the meaning or the judgment rendered in Bangalore water supplies case.
Yeah.
That is the first issue. Now the second one, because intent was to keep the welfare functions out of the purview of the definition of the as we change, the time changes, we get into, the government gets into many welfare legislations, welfare activities, so many other regulatory mechanism, where under the government never wanted to bring it under the definition of the industry as it defined under the, in the judgment of Bangalore water supply case. Now coming to the second issue.
So this will take within its sweep even a small canteen run by defense research. So will it take within its sweep a small canteen run by defense research?
Yes, completely kept out under the new one.
What you are saying?
Yes, that's completely kept. The meanings, if you read it, the section 2, 2P2, any activity of the appropriate government relatable to the sovereign functions of the appropriate government, then including all the activities, very sweepingly it is given, carried on by the Department of Central Government dealing with the defense. So all the activities dealing with
Research.
Defense
Defense
research.
research.
correct, defense research. I'm grateful. Defense research.
So defense research, when you are using, that means other departments, other than defense research, would be included?
Correct. It could be relatable to, then relatable. The first expression should be relatable.
Suppose a canteen, my learned
Yes.
brother says a canteen is being run by a defense organization.
He says that it will come.
Then
How is
relatable.
that relatable to defense?
Relatable. Then we have to see whether it's relatable or not.
He says that it will come within the first part.
First part, relative.
Remedy then.
Remedy, they have other remedies. The either 226 remedies are there, tribunals are there, various tribunals are constituted,
Such as
or 226.
central tribunal.
So, in
What tribunals are there for the state employees, but
yes, in central tribunals in this
Central,
Let him be clear about this.
industrial
it is not an industry where to
that is
go.
the
Central Industrial Tribunal,
correct.
if you say it is not an industry,
Yes.
then where will the employees go? To file a suit or under 226?
If it is a state, they can go under 226. If not, to suit.
But say, now you have Central Industrial Tribunal.
No, whatever the other forums, we have to bring it out of this one, the definition of industry as such. That was the intent, not to bring within the definition of industry. Please.
The way
No, there is
you
also
are
labor.
Yes.
interpreting these provisions
Yes.
in aid or tool
Yes.
to restrict or redefine the ratio of Bangalore water supply.
Yes.
Would it not, in effect,
Yes.
give a retrospective operation to the labor code when the legislature gave operation of the labor code from a posterior date of its passing, that is from 2025.
Right.
And now if we, in order to interpret or revisit the ratio of a 78 judgment,
Yes.
use them as interpretative tools,
Yes.
would we not fall in re-legislating a prospective law as a retrospective law?
It is not actually.
You have used a word,
Yes.
clarificatory law.
Yes.
Do you really wish to press that argument that the labor code is a clarificatory law or is a law which redefines labor relationship between employer-employee,
Yes.
where earlier vested rights were defined in the repeal law, namely the 1947
Yes.
Act.
I cautiously submitted, it is not a clarificatory law, but it is in the nature of clarificatory law.
That's exactly
Yes,
where
that exactly I wanted to draw the
lies.
distinction.
That's exactly.
Yes.
Are you going to
Yes.
pass off a wolf in
Yes.
sheep clothing?
That cannot be.
That is where my question lies.
It has to be taken,
If your interpretation is to be
Yes.
accepted,
yes,
we would be
yes,
unwittingly giving retrospectivity
yes,
through our judicial imprimatur in reviewing Bangalore,
Yes.
retrospective, and thereby restricting or interpreting an existing industrial dispute in the light of 47 Act.
no, it has to,
Because-
yes,
because-
it is only for the purpose of interpretation. Interpretation of, even then also in the 1947.
That once we interpret Bangalore
Yes,
in the shadow of the 2020 core,
yes,
and we carve out sovereign functions
yes,
by giving sovereign function a wider interpretation, as the learned attorney and you are proposing,
yes,
we are importing the restrictions of the 82 as well as the 2020 labor code.
yes,
Although the legislator did not operate, introduce them retrospectively.
yes.
Now, in this interpretation, the danger is a dispute, an industrial dispute, which is in existence at a various stages of adjudication, would now be colored by our interpretation,
Yes.
which will be binding on Article 141.
Yes.
To all these disputes. We'd like a
I wanted
clarification
to
on this.
add something.
I don't
The
think
point
it
is,
should be in a
the
cloud
point is
area.
very simple.
Yes.
Mr. Attorney, that's why we were pointing out. 1982 amendment. Will of the legislature, but it became wishful thinking of the executive, never
Executive block.
implemented. Therefore, a provision which never came into force, a provision which never saw the light of the day, we can't probably rely upon that. 2020, we will consciously not refer to because of the caveat already put in that if there is a challenge to that provision.
Absolutely.
But that does not mean that we are helpless. Today, there is a reference before us. We are directly examining the question that whether the interpretation of the original provision itself in Bangalore was correct or not.
Yes.
If that interpretation was wrong, if the provision has been completely misconstrued by giving such a wide meaning, then we will correct our mistake. Very simple.
One more.
We will rectify our error.
Your lordships have framed. the
Particularly when the
second
original definition didn't have the
That's why we are sitting in 9.
power in at all.
Since your lordships in the references, the second part of the first issue has come in like this. Whether these instruments of law later in point of time will have an impact. Suppose I close my eyes to the second part of the issue, the only way we'll answer the question is whether it is good law or bad law. But for the purpose of reaching that conclusion, is it open to the court to look at each one of the legal instruments and say, do I gather anything from them? Can it be of any help? Whatever way you describe them. So court may say, no, I can't look into them at all.
Mr. Attorney, without,
can't look into
without
them at all. The
taking the
court may say, I look into
1982
them.
as well as the
That's right.
2020
Since
quote unquote legislations, whatever they are, you can still make your argument on the basis of original definition.
but
You
in
don't
my
have to
understanding, the
refer.
second part of the issue may or may not be strictly relevant to answer this.
Yeah, you don't
That's-
have to refer unnecessary.
Usually what happens, an earlier law is considered to find out the subsequent law, how far there are changes, it advances the purposes of the act.
All the detailed
Because the
examination will
testing
have to be
reverse-
undertaken. Detailed examination will have to be
Yes.
undertaken. Correct.
Earlier law is always taken into Hayden's rule, mischief rule. Now subsequent law.
Yes, please. The sovereign function which has been, the interpretation which has been given in Bangalore, Bangalore water supply case, that has been rendered by keeping in mind the common law system or the colonial, by applying the colonial jurisprudence, which may not apply to our system. Especially,
Is very simple.
yes,
That the original definition of 2J
yes,
never contemplated
Yes,
and cannot be stressed to
Correct.
include either sovereign activities
yes,
or sovereign related activities.
Correct.
Though word related is figuring in 2020 code,
Yes.
it's a very general nomenclature word.
yes,
So it can be or any activity which is allied to or which is done the dominant part, predominant activity is the sovereign activity.
Yes.
But any other activity which is done in furtherance of, in assistance of, or in achieving a sovereign activity, that activity will also be protected along with the sovereign activity. And therefore, that will not fall within the ambit of 2J originally as unamended provision.
yes.
That is what precisely.
That is not.
Sovereign activity as we normally understand under the Western jurisprudence or the common law system, that cannot be applied to understand our system. That cannot be applied. Because fundamentally, when we go to the sovereign function, which means the certain functions which are normally not answerable to the courts, which cannot be reviewed. But when we,
That also again, you need not to depend upon any foreign jurisprudence.
yes,
Your argument can be very well that any activity which is in part 4 of the
Part 4.
Constitution is a constitutional obligation.
obligation on the state.
And therefore, an elected government
Yes.
is obligated
Obligated.
to perform those duties.
Government.
If you don't do, then you fail to perform your constitutional
Absolutely.
responsibility.
Absolutely.
When you perform those duties, these are your sovereign function as a state.
As a state.
That you are obligated under the Constitution.
Constitution, we are required.
Sovereignty is drawn from the Constitution itself.
Constitution. Constitution.
And therefore, all those activities fall in that
Yes.
ambit. Social welfare activities will also then, according to you.
In that judgment, actually they confined to three facets. That is number one, by applying the Western jurisprudence of the sovereign function to say that, see, normally the functions relating to the defense, which are normally not answerable to the courts, but that cannot be applied to our system, where the judicial review is applicable to everything as a basic structure. Therefore, we can't apply the meaning which is ascribed to the sovereign function as in the colonial era. So here everything judicial review is permissible. Therefore, we have to test from the angle of what is applicable to our country, what is applicable to our system. Especially we derive every right and the work from the Constitution. That has to be understood accordingly.
Certain activities
Yes.
which the state was performing,
Yes,
public sector units were there.
yes,
Now they are privatizing, for example, ITDC,
yes,
Tourism Development,
Correct.
and Tourism Development Corporation.
yes,
They are privatizing, they are selling the hotels, everything. They are being purchased by private entities and they are running it.
yes.
Now, what happens to those? There is a, you see, there both ways there are changes.
Yeah. The regulatory mechanism, still it is retained with the government. That is the change scenario, where the government lays down the broad policy, what has to be done and how it has to be carried forward. And when we go into the contractual field, there are other remedies provided in the respective fields. So ultimately, there is,
My sister's question is very simple.
yes, yes,
It may be a part of your constitutional obligation to promote, say, for example, industry, because you want to generate employment. You want to have an equitable distribution of wealth that you can do only when you spread employment, make the other people inclusivity and participatory role you give assigned to them. But it may not be your responsibility in terms of part 4 to run, suppose, an iron ore industry or to establish hotels and to run the hotel. That may not be your activity. So therefore, that individual activities can very well conveniently on facts to fact basis can be excluded from the ambit.
that has to be tested on facts. That only government can enter into contracts, government can enter into business. The such activity which is totally unrelatable, they can be excluded, no doubt about it.
For instance, an example is printing currency is a sovereign function, but a mint is an industry. So therefore, the actual activity of carrying it, the court says, policy says it will be done by so and so, it will be an industry. Therefore, the
Instead of
sovereignty
taking
may or-
case by case basis and burdening the court to identify which is a sovereign
Exactly.
activity, which is not a sovereign activity, like Contract Labor Act and many other statutes, wherever you think a particular industry is necessary to be excluded from the provisions of the act, you indicate in the schedule. So you don't do anything like that. You just leave an expression. In the first act, there is no expression of sovereignty. And today, whole thing depends upon how we define that expression sovereignty. It is
Sovereign
very, very.
That has become a challenging task.
Why should we be defining sovereignty?
You leave your activity to the presiding officer of the industrial tribunal or labor court. With his fanciful ideas, he can hold anything as sovereign function and he cannot
us.
hold.
Put it in a schedule, you tell us, then we will test the legality in a judicial review. We will say if you wrongly included, we will exclude it.
On
If
the
it is
other
rightly included, then the purpose is served. The industry is out.
Here they can include by a notification any activity as an industry, not exclude,
Exclude.
but include. This you can include.
But now we can exclude. Now it can be excluded. Mhm.
1947, we were just examining,
Yeah.
used just 25 words. I counted from industry, means is second word, any is third word. You counted 25 words. And today from 1947, 2026, how many words have been contributed in various judgments? Count them in trying to interpret what that definition is. Use such expressions so open-ended, open textual, and then the litigation is unabated. Unabated. It's a classic example of how a definition can fail.
For in many areas, for the purpose of interpretation, people have to rush to the court. That is the only solution, even in the. So that is the second line of point which I pointed out. Especially it will affect the education, healthcare, and social security measures, which they are, if they are brought under the purview of the sovereign function, that will be affecting the, in this page number 6 in para 12, I pointed out. It's a responsibility of the government as a welfare measure to bring education, healthcare, forest. Forest, we can't do anything. It has to be, it is the function or the duty of the government to preserve the environment, to preserve the forest. There are various legislations under the coming under the broad definition of forest. Even the irrigation department, laying the canals, construction of dams, exercise of eminent domain power. In all those activities, we can't bring the principle of industry for the purpose of Industrial Disputes Act. Now, in the next.
Water supply activity, a water supply activity, the state does not supply drinking water. Is it not a constitutional failure of the welfare state?
It is.
And if that state supplies the water, you say it's an industry.
Industry, that cannot be.
Therefore, this distinction can always be made.
Correct.
But if you start running showrooms and selling some state products and all these things, then you are trying your hands in business and industry. Then of course your activities are like that.
Directly getting into the business.
Even if you don't earn profit.
Yes.
Yes.
Even if there is no element of profit.
Yes.
The very fact that you have decided to run as a public entrepreneur and to run some industrial activity, you are bound to.
Yes. Getting into the business, no doubt it is. Getting into the business, no doubt it is permissible for the state. But however, directly if you get into the business, then no doubt we can make the other, the definition within it can be brought within the definition of industry. But in some of the issues, the generation of the revenue would be only an incidental. In the state functions, generation of the revenue would be only an incidental. But the primary function is to give certain benefits to the people, which is constitutionally mandated, where no doubt there will be some kind of revenue generation. But the primary object test, the test would be whether it was the primary object of the government to give the certain benefits as a welfare measure. That should be the test. If the profit earning alone is the motive or the criteria, then no doubt the definition of the industry that can be restricted to say that yes, it covers under the definition of industry for the purpose of application of the act.
If there is no profit, it can still be industry.
Yes.
That is what the judgment says.
Correct. Now in para 17 of my note, in the present proceedings itself, when it travels to the Honorable Court, before the Honorable Court, 5 judges had expressed their concern about certain aspects, which I quoted. Kindly take to para 17 of my note. That was in this present proceedings itself. It's para 38 of that order. We also wish to enter a caveat on confining sovereign functions to the traditional so described as inalienable functions comparable to those performed by a monarch, a ruler, or a non-democratic government. The learned judges of in so-and-so's case seem to have confined only such sovereign functions outside the purview of industry, which can be termed strictly as a constitutional functions of the 3 wings of the state, executive and legislature and judiciary. The concept of sovereignty in a constitutional democracy is different from the traditional concept of sovereignty, which is confined to law and order, defense, lawmaking, and justice dispensation. In a democracy governed by the Constitution, the sovereignty vests in the people, and the people is obliged to discharge its constitutional obligations contained in the directive principles of state policy in Part 4 of the Constitution of India. From that point of view, wherever the government undertakes public welfare activities in discharge of its constitutional obligations, as provided in Part 4 of the Constitution, such activities should be treated as activities in discharge of sovereign functions falling outside the purview of industry. Whether employees employed in such welfare activities of the government require protection, apart from the constitutional rights conferred on them, may be a subject of separate legislation, but for that reason, such government activities cannot be brought within the fold of industrial law by giving an undue, expansive, and wide meaning to the words used in the definition of industry. So it has to be the meaning of the industry that has to be understood, keeping in mind the present setup, the constitutional obligation, constitutional mandate on the government, and not restricting or strictly saying that, yes, it is the sovereign function or not. And the last limb of my submission in para 18, the consequences of narrow interpretation, which I pointed out, especially when it comes to government employees, they are all regulated by Article 309 or 311. There is a separate service rules. Insofar as other employees are concerned, state administrative tribunals are there, service tribunals are there. In state government level, there are educational tribunals. So all those forums, they take care of the situation. And depending upon the service rules, depending upon the terms of their employment, the interpretation can be given. Employees and the employer would be protected, or the rights or the liabilities of the employer employees are completely regulated by such statutory regimes. The further consequence, as noticed by this Honorable Court itself in the next judgment in para 21, which I quoted in 1997, 6 SCC 723.
Para 13 is relevant to, first we can skip the next paragraph.
Para 13.
13 of the judgment you are.
Yes, yes, that's right. 13 only. Yes, para 12 and 13. Para 13.
I'll query my sister at that time. What will be the alternate remedy?
Remit.
The forums also they have described, mentioned about the alternative forums which are available to safeguard the interests of both employers and employee. That is also, and there will be conflict of forums. It will lead to serious consequences. In the next para, in the final I pointed out, all these welfare measures or welfare steps will be hampered by giving scope for undue strikes, layoffs, or collective bargaining conflicts. That may not be advisable in the present scenario, may not be the intent of any developing state.
In para 23 of your note also you
Yes.
highlighted the same.
I'm grateful. Consequence of our industry. It's incompatible with the. Yes.
1923.
By keeping in mind these aspects, my request would be to interpret the definition which has been interpreted by the Bangalore water supply case, sovereign function very broadly, and to not to include everything under the definition of industry, and accordingly I ready to pass appropriately. I'm grateful for.
Thank you. Thank you, Mr. Speaker.
Sir, as my sequence is concerned, I'm supposed to be the third one.
I'm saying
My
No, I'm for the state of UP, the other council here. But the problem is that time has been consumed.
Years of.
I'm for the state of UP by the irrigation department. But for forest,
State has argued,
yes. I'll argue only one.
if you have any one-line argument
No,
additional.
I'm not having one line argument to support it. I am on a one paragraph of the Bangalore waterway and then will finish my argument within 5 to 10 minutes. I am on the section 6J itself because what is the.
Give the para number, we'll go read.
My lord,
Which paragraph you want to read?
paragraph 141 of the Bangalore.
141.
Yes.
Learned Attorney General has read.
No, that has been read, my lord. Therefore, I wanted to say something regarding that only, and then I'll finish my argument because that is the problem with the whole judgment. Lordship, may kindly allow me to read the paragraph 141 carefully, and then what the two principles have been applied therein, nociter and sources, and expanding role of the inclusive definition. On these two aspects, I'll make my submission and finish that.
Disputes like them. Yes, Mr. Ardani, 5 minutes only, please.
Well,
State time is over.
yes, well, that's why I said that Mr. Natraj exhausted the time.
Fine.
Lordship, I'll do one thing. Yes, well.
Just 5
Lordship,
minutes.
I'm reading that, and by reading, I'll explain what is there. Although section 2J uses words of the widest amplitude in its two lengths, their meaning cannot be magnified to overreach itself. They say the undertaking must suffer a contextual and associational shrinkage as explained in Banerjee, and in this judgment, so also service calling and the like. Your Lordship may kindly see paragraph 13 of the same judgment says that the principle of ejusdem generis has to be applied, and the one word should take colors from the others. So, my lord, the restrictive meaning is here is that undertaking must suffer a contextual and associational shrinkage as explained in Banerjee. And in this judgment, so also service calling and the like. This yields the inference that all the organized activity possessing the triple element in first principle, although not trade or business, may still be industry, provided the nature of the activity, that is, namely the employer-employee basis bears resemblance to what we find in trade or business. Lordship, what I am saying is that the core issue they say that the employee and employer basis is there. Therefore, they say that organized activity will that this yield the inference that wherever they find this activity, the employers and employer relationship, that would be an undertaking. That's what I am saying is this is not the Schenken interpretation of the word undertaking. Now, my lord, they move further because what they say, the Schenken interpretation, now they say they're expanding it. This takes into the fold of industry undertaking, calling and services, adventures analogous to the carrying on the trade or business. Now they say all features other than the methodology of carrying on the activity is other than that is in organizing the cooperation between employer and employee may be dissimilar. Lordship may kindly see that now the trade and business, what is there in the other definition words? What is there in the trade and businesses? They say that organizing the cooperation between employer and employee, barring this, there may be dissimilarity. So therefore, if this is not a trade, it is not a business, it is not a manufacture, and if the element of master and servant relationship is there in a systematic activity, then it is an undertaking. So therefore, my lord, my submission is not from the perspective of the workman. This is the activity of the industry which is relevant, and therefore the activity which is analogous to the trade, business, and manufacture may be taken to be within the fold of industry, but not otherwise. And so far as the sovereign functions aspect is one liner. The Lordship may say the definition says and including service, etc.
You have seen your note.
My lord, and including must be read as and comprising. And that is why this honorable court has referred to that in the judgment.
On word inclusion are very well known.
So my lord might say that because I'm for an irrigation industry, so the functioning of the irrigation industry is a constitutional duty. So therefore, the irrigation department and so far as the dam management, so far as the disaster management, these are the activities, disaster activities, they cannot be transferred to the private sector. So therefore, this is not analogous to trade industry. That's what I'm saying by way of illustration. Thank you.
Thank you very much. Yes, Mr. Navde.
I am in two matters. One is the Mumbai University, where the issue is education. And the second matter is for state of Maharashtra, where the issue relates to forest. Now, the essence of Bangalore water supply is in para 140, which has been shown to your lordship. It contains the triple test. Now, my first objection to the triple test is that it is not based on logic. It does not flow out of the wording of the relevant part of the statute. It is straightaway borrowed from an Australian judgment. It falters on the altar of reason, which I'll indicate to your lordship in few minutes. Taken to its logical conclusion, even the sovereign functions would be within the sweep. Take, for example, the judicial functions of the state. There is the employer, either the government or the courts. There are employees, cooperation resulting into service. Then how do you take it out? There is no logic. The court in Bangalore water supply carves out three exceptions: the sovereign functions, the religious functions and aesthetic functions. In case of religious functions, it's also a service. So by what logic do we restrict aesthetic? Court says that holding a mushaira is a cultural activity, therefore out. In other words, tested on the principle of logic, triple test falters. Now the second issue is whether does it flow out of the wording. Now let's have a wording of the statute. And once the triple test is out, then we are on a clean slate. Now, kindly see the wording of the statute, my lord. Industry means
Any note has been given, Mr. Joshi?
my note is there.
Volume 106.
Volume 1, page 107.
Got it.
So kindly see, industry means any business, trade, undertaking, manufacture, or calling of employers, and includes any calling, service, employment, handicraft, or industrial occupation or avocation of workmen. Now, the material words are business, trade, manufacture, calling. Now, the word calling, the dictionary meaning of the word calling is also trade. Now, therefore, your lordship will see the word undertaking is waged on one side, business and trade, and on the other side, manufacture or calling. And therefore, it must necessarily derive its content from the words preceding and the words following. Now the judgment begins with a reference to the principle of nauciter of society. Kindly similar to a few paragraphs.
Let's go to the
So if your lordships come to paragraph 2, page 227, paragraph 10, page 230, paragraph 13, so it begins at page 202. 2062, I stand corrected. And the internal page 227 of the report. Your lordship got para 2.
Yes.
Esoterica is anathema for law affecting the common man. So the last para on that page, internal page 207 and 2079.
Judgment volume.
Yeah. Your lordship got the last para.
Yes.
Esoterica is anathema for the law affecting the common man in the common life. And so the starting point of our discussion is the determination to go by the plain, not the possible sense of the words used in the definition, informed by the context and the purpose of the statute, etc. Now, this approach your lordship will find also in para 10, page 230, para 13. I am referring to the internal pages of the report. Your lordship got the judgment?
Yes, yes.
Yes. Then para 30, para 10, page 230, para 13, page 230, para 40, page 241 and 242, and para 42, page 242. These are the paragraphs where the learned judges refer to the literal meaning of the terms. And this approach then subsequently is abandoned. And then court straightway goes to the Australian judgment. Then second, the principle of Nausitor and Society, your lordship will find is referred to in para 2, same page 227, para 13, page 230, para 37, page 240, para 38, page 240. The court refers to this principle while construing the term undertaking, but not followed, given up. So this is one aspect. Then kindly come to para 2 again for a purpose. The court says that we cannot rely upon foreign judgments. There are no absolutes in life which is relative. What is an industry in America? Your lordship got that? What is an industry in America or Soviet Union may not be one in India, and in our own country, what is not industry decades ago may still be now so and so. Then in para 44, your lordship will come to para 44, where several judgments of foreign authorities are quoted, referred to. But see what the court says. See, Justice Subbarao, with uninhibited logic, chases his thought and reaches certain tests in Nagpur municipality, speaking for a unanimous bench. We respectfully agree with much of his reasoning and proceed to deal with the decision. If the ruling were right, we think it is. The riddle of industry is resolved in some measure. Although foreign decisions, words and phrases, lexical plenty and definitions from other legislations were read before us to stress the necessity of direct cooperation between the employer and the employees in the essential product of the undertaking, of the need for commercial motive, of service to the community, etc., as implied inarticulately in the concept of industry, we bypass them as but marginally persuasive. Now, several judgments are cited before the court, foreign judgment, bypass them. And we straight away go to the Australian judgment. And the whole concept of triple test is borrowed from the Australian judgment. Yeah. And more so, the reasoning of the majority judgment. Your lordship will see Justice Isaac judgment, which is followed entirely, is a minority judgment. And there is not a word about the majority judgment. So therefore, my respectful submission is that court has proceeded with a value-loaded approach. The worker-oriented approach. What I feel is that we need to objectify the process of interpretation. The time has now come to objectify that process. So what is the plain meaning of these words? Trade, business, manufacture. The word undertaking is placed in between these words. The principle of Nausitor and society must apply necessarily. There is no escape from it. Now come to the other aspect of the matter. Now kindly see, my lord, why triple test and the concept of sovereign functions, they are correlated. Now, according to me, we don't have to go to the concept of sovereign function. The simple test is this, that essential government function, which is, it is statutory obligation. Let me formulate it. Essential government function which arises out of its statutory obligation. Now we'll begin with Nagpur municipality case. What is the reasoning of the court? That providing road, providing water supply, and other civic amenities is something which a private entity can do, and therefore it is an industry. Then the court goes on to say that since the principal activity is industry, even the tax department is an industry. Now, this is where the logic falters. Now let us apply the test of principal activity. The test is very simple. Whether it has commercial roots. If it has no commercial roots, even if it results in manufacture, production of goods and services, it is still not an industry. Now take for example the irrigation facilities. The number of welfare activities that the state performs, they are not rooted in commerce. They are in discharge of the state's obligation. Now for example, construction of roads. This is something which a municipal corporation is under an obligation to do so. Essential governmental function. Now let's come to the university, with which I am more concerned. So university performs three functions. Number one, it holds examination and confers degrees and diplomas. This is something which a private individual cannot do. It's an essential government function performed under a statute. A statutory obligation is not rooted in an economic activity. It is not rooted in commerce. So instead of going into the concept of sovereign function, we must go into the concept of essential statutory function of the state. Now, what is the second function of that university discharges? It's a regulator. It prescribes qualifications for appointment of lecturers, professors, etc. It also prescribes eligibilities for the students. Now, the affiliation of colleges and several other things which no private individual can do. The third is teaching. Now, as far as teaching is concerned, I will take it a little later. So, University Grants Commission, All India Technical AICT, all these bodies, these are essentially regulatory bodies. Now, in discharging their respective statutory functions, there is cooperation. It results also into rendering service. But it is not an industry because they are not rooted in commerce. So we come back to the same thing, that how do we interpret the word industry as the dictionary meaning of the terms that are deployed in the definition of 2A. Now, let us go to teaching. Now, what is the essence of teaching? Is intellectual enlightenment. It cannot be compared to a material service. Education ultimately is the foundation of the progress of any country. Article 41, directive principle of the state policy, requires the state to take steps to provide education.
21A, fundamental.
Article 21A, now education is made a fundamental right. And much before that, Even in Unni Krishnan judgment, your lordship read that as a part of fundamental right. So therefore, what state does as its statutory obligation cannot be considered as an industry at all. So that is another aspect of the matter.
21 and 21A is now constitutional obligation, not the
Constitutional
statutory.
obligation. But earlier in Unni Krishnan, your lordship read it as a fundamental right. So therefore, we apply a very simple test whether it's an essential statutory obligation of the state. If it is so, it is outside the purview of, because it is not rooted in commerce. So as far as university aspect is concerned, there is another point which has to be considered. The teachers are admittedly not workmen. Even Bangalore water supply proceeds on that assumption. Of course, there is a doubt expressed. They may or may not be. Whichever way, as far as teaching is concerned, therefore, it is carried on by persons who are not workmen within the meaning of Section 2S of the Industrial Disputes Act. The other staff members, their help is of a marginal nature. The judgment also refers to a university having a transport department, printing press, etc. Now, these are incidental activities. In Nagpur municipality case, the court formulates a test of essential and primary functions. And since the essential and primary functions constitute an industry, therefore tax department is an industry. But when it comes to the education, the court says that these are activities. In large scale prasad making, the court says it is an industry. But here the test of essential function is not applied. If the whole judgment defies logic. So the last aspect is at several places your lordship will see the judgment says that we need a mechanism to solve these disputes. No debate on that issue at all. As far as government servants are concerned, right from the beginning of the civil service, we have statutes which prescribe recruitment process, which prescribe qualifications for appointments, which prescribe service conditions, and all aspects of service conditions, salary, wage, terminal benefits, everything. And if services are terminated, there is a mechanism to deal with the termination also. So if there is a statute in operation which takes care of all, we don't need Industrial Disputes Act. I'll give one example. As far as government servants are concerned, their salary and etc. are fixed by the rules framed under Article 309. Now let us take a dispute to the tribunal about wages. The tribunal exercises the judicial power of the state. Now can it alter the wage structure which is prescribed by the rules framed under Article 309? It obviously can't. Because then the tribunal will be discharging a legislative function which it cannot do. So therefore, while interpreting the definition of industry, these aspects are required to be taken into account. Of course, I do concede that merely because an activity is carried on by government, it does not cease to be an industry. Maybe. But where there is a discharge of a statutory function, then it goes out. Now, the second aspect is, as far as education is concerned, the code proceeds on the footing that for university there is no statutory regime. So the first University Act in this country is Indian Universities Act 1904. So right from 1904 till today, all university teachers, professors, other staff members, their service conditions are under a statute. And there is a tribunal also. So therefore, the purpose of industrial disputes is served also by the other relevant statutes. This aspect is not taken into account. So I think that's the question. And so the court was conscious of that fact. And para 50
Statute has.
As a remedy like this.
No.
Para 50 of the judgment. So today, all aspects of teachers' employment, the subordinate staff employment is governed by statute. So therefore, the anxiety of the court that there should be some mechanism to deal with this is taken care of. And this has some bearing on interpretation of the definition of industry. So these are my submissions, Lord. Thank you.
Thank you. Thank you, Mr. Ram. Yes, Mr. Agrawal.
Please, my lords. I appear for the state of Karnataka in 4 matters. One deals with the conservator of forests and 3 are Zilla Parishad matters, my lords.
Forest,
I'll give the list, your lordships.
forest and
Zilla Parishad.
broadly these two categories.
One
These are-
minute.
I'm
So
sorry.
before that, I conclude in the respect of forest, I have set out in a small statement that what are the essential statutory duties which are performed through forest department. They give copies. Yeah. Your lordship may have, these are statutory obligations.
It may not be exhaustive, but then it can be illustratively helpful.
And the forest department deals with the forest produce that's incidental. So therefore, something which is incidental can't be taken as the main purpose of the forest department.
And what would
So we'll also circulate.
I don't want the other. We on this. Okay. There is a constitutional authority under 243 and they don't want to be checking for industry. Areas for developer have also been given some sometimes.
The last one.
I think.
I think what's going to bring in ask to go and start. I think before that is, if we ask, who start?
That will be definitely, I put barely 5 minutes. That's 7.
Sir, last thing, permit me to circulate the Maharashtra Universities Act.
You have already circulated.
We have already.
There with us.
I am told it is circulated.
Yes, we have got it. Got it.
Gratefully.
Thank you, Mr. Navke. Yes, Mr. Zia.
Please, my lords.
How it's done. Now you can.
I have a short submission to make. My short submission is that today your lordships are sitting in 9 judges, primarily because a unanimous judgment of 6 judges was overruled, 3 + 1 + 1 and 2 dissents. My lords, the unanimous judgment and a clear line was laid down in Safdarjung. And my lords, if your lordship sees the composition of the Bangalore Waterworks case, my lords, I think one factor which actually led to the confusion was simply this, that there was a retirement pending. Justice Beg in his judgment says that I have to give this judgment today because tomorrow I retire. My lords, I have some 30 years of assisting at constitution benches and sometimes arguing them, my lords. And it's been my experience that sometimes these retirements end up with judgments which are given in a hurry and then cause problems later. But for the fact that in Keshavananda Bharati, you had that signed order by 9 of the judges, we may have been wandering around trying to figure out what the ratio was. In my experience, my lords, I assisted in TMFI. And TMFI also, we had a deadline in as much as Justice Kirpal was to retire. And after that, my lords, then we because of TMFI, to clarify it, we then had Islamic Academy and PA Inamdar. Therefore, I have only one request first to make, my lords.
That is why I ruled out this kind of stress.
Obliged, my lords.
But he's retiring this year.
Obliged, my lords. And my lords, I also take some strength from my Lord Justice Datta's judgment in Aligarh, where we get to know how your lordship's conference. And it's my request, my lords, that whenever your lordships draw the line, your lordships draw a straight line. My written submission today is essentially to say, it's an additional written submission. Please don't go by the earlier written submission which has been filed. I'm sorry, please don't go by that. Please don't go by the state of Karnataka submission which has already been filed. I have an additional one. 1, 2, 3, 4, 5, 6, 7, 8, 9. और दूसरे किसके पास है? जिनको देना है दे दो, एजी को दे दो और please we'll airdrop if you don't mind. At 4 o'clock.
Fine.
Please. I'm sorry.
Cannot submit matter to the court without giving it to counsel.
No, I've just run short of copy. I'll give. I'm sorry. Yeah, I can't make it. Please, my lords. My lords may skip over the first page and let's come straight to this. I'm sorry.
My dear, you don't get it.
This is not part of the compilation.
No, it's not part of the compilation. We'll add it today. And
Please ensure that these are also given to.
This will be added.
Not only to council, there are 2 MIC.
Yes, we've given it to the nodal council.
Also be given.
We've given it to the nodal council.
I should also get it.
We have not made We'll do it. We'll add it. Please, my lords. My lords, this will take about 10 minutes. I mean, I'm free, either which way, my lords. It may take 10 minutes or it may take slightly more. Would your lordship
So, Mr.
Next, my lords. Yes.
10 minutes?
Plus 10 to 15 is what I would request if your lordship will.
5 to 10 minutes.
Plus 10 minutes, I take 10 minutes then. I take 10 minutes.
And 10 minutes more to all, 2, 3 minutes. Mr. Jaideep, are you also there?
Yes, please.
For the state
The
side?
temple matter. The temple matter.
Temple.
Temple has been held to be industry.
Industry.
On behalf of AIMS, if your lordship may permit 5 minutes, AIMS New Delhi. AIMS.
How much, Mr. Jaideep, you want?
Millet 15 minutes.
15 minutes.
We are now all giving propositions because the material your lordship has seen.
We only state arguments and.
Just summarize. Yes, 15 minutes.
So IPF for the state of Madhya Pradesh, 5 minutes for any time. 5 minutes.
No repetition,
Summarize-
please. No repetition.
No repetition.
5, 10, Mrs. Stan, we will request 10, 15, Mr. Jaideep, 15, Mr. Hegde, 5 minutes more here and there.
I appear for research organizations, ICMR, etc.
Rest, you can do one thing, you give your small notes, we'll take care of that. You can point out that additional point is raised in para students of the note. We'll take care of that. And please, those who are filing note, give to two learned Micus, Mr.
We'll do
Kama and Mr. Sen Gupta.
We'll do that.
Both have been kind enough to assist us because we have to give time to them also. Mr. Kama would like to have in the end when both sides, I think that will be the ideal. Because then we will request both of you to sum up everything.
Grateful, 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 man.
So tomorrow, 10:30.
Obliged.
Then it can be circulated and.
I'll do it immediately. Postmaster.